Good morning, all. This appeal hearing is in the matter of CFI 046-2023 and is being held by way of video conference before the Chief Justice Zaki Azmi, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The applicant is represented by Seoul International. Lead counsel is Mr. Michael Pratchett-Joyce. The respondent is represented by El Tamimi. Lead counsel is Mr. David Holloway. Thank you, Chief Justice.
Thank you, Alia. Okay, Mr. Patrick, Michael, I call
Yes,
you Mr. Joyce, Patrick Joyce, Mr. Patrick Joyce. I'm so
Chief
sorry.
Justice, I'm burdened with a very long and rather unpronounceable name.
Yes.
And previously, we've fixed on you referring to me as Mr. Michael for convenience, and I'm more than happy for that.
Okay,
that
I will
basis
call you
to
Mr.
Continue.
Okay, I can call your Christian name by Mr. Michael.
Yes. It makes life simple.
Okay, Mr. Michael.
Yes.
Before you proceed on, can you sort of remind me of what is this application for permission to appeal against which decision of Mr. Justice Jeremy Cook? There are a number of appeal decisions that he has made. Which of these decisions are you seeking permission to appeal against?
It is essentially his order of the 19th of December last year.
19th of December.
Yes.
2023.
Yes.
And these are against, these are the orders. He made the orders.
He made the orders on the 3rd of February last year.
3rd of February. Okay, what are the orders?
The orders comprise 3 orders: an enforcement order, an interim charging order, and a worldwide freezing order. And pursuant to, in particular, the first and second of those orders, a consequential order for the sale of the first defendant's shares in the second defendant company.
Okay. Mr. Michael, normally when the court makes an order, your client didn't turn up on the, or rather nothing happened on the day of the return. He was supposed to make some declarations of what he owns. He did not respond. That's why, since this order was made on the 3rd of February 2024, today is September the 2nd. Like what, 7-8 months have passed?
Well,
can you still appeal at this stage?
In our submission, we can absolutely, because what happened was that the matter was the set-aside applications were dismissed or refused on the 19th of February.
Yes.
We then sought permission, or my client then sought permission to appeal, which
when was that? When was that permission to appeal sought?
That was sought immediately after the order was made on the 19th of December. The
19th of December, 19th December 2023.
No, 22nd. The order, Chief Justice, was made on the 19th of December 2023. The appeal notice was put in on the 22nd of December 2023.
Yes, 22nd. That's longer. It's nine months ago.
Well, yes, but the appeal was then listed for hearing on the 28th of May, and the appeal was the permission to appeal was refused on the 28th of May, and then
28th of May.
This year, yes.
Yes. Again, that is 4 months ago. No, 3 months. May, June, July, August, September, almost 4 months ago. Okay.
Yes, and we then sought, we then put in, there was a short extension of time, but we renewed our application on the 24th of June. We have been trying to get this matter before the court, and counsel availability, admittedly on both sides, but counsel availability over the long vacation has caused some difficulties in relation to this.
Sorry.
And this was the first opportunity we've had.
Can we work back? Can we work back? Today is the 2nd of September.
Yes.
2nd of September, and we are appealing, seeking permission, renewed permission to appeal against a decision, well, not against, in respect of which the first permission was given on, first permission to appeal was refused on. When was that?
On the 28th of May.
28th of May. Yes, 28th of May. What does the rule say? When can you apply for permission to appeal, a second permission to appeal or renewed permission to appeal? What does the rule say? Can you help me, please?
Yes, Your Honour. It was 3 weeks, and we
3 weeks.
applied for a short extension, which was granted, so that the further appeal notice, which we needed to lodge, was lodged, in fact, on the 24th of June.
24th of June.
Yes, Your
Yeah,
Honour,
please.
does Your Honour have a speaking note which we provided?
Yeah, I just arrived this morning.
Yes.
I've not seen it. I just saw email, speaking notes, but I've not done anything. I'm not read. Your solicitors are very slow with everything. Very slow, Mr. Michael.
Your Honour, I can only apologise. It's a collective apology, because obviously I am part of the legal team as well. So it falls on my shoulders as well. But the purpose of the speaking note was to provide ready references to the information that Your Honour is seeking. And Your Honour, could I just take you through?
Yes. Give me time to get the thing through. Okay, I got speaking D1 speaking note for PTA.
I'm obliged. Section 1 of this speaking note sets out the procedural steps essential to the present application. So Your Honour will see it's bullet point form, so it's as concise as possible. This is a renewed application for permission to appeal. The test is one of arguability, and I've referred to the relevant provisions in the rules in that regard and given page references to the bundle. Specifically, the proposed appeal is against the court's refusal to set aside orders which had originally been made by the court on the 3rd of February 2023. Going over to page 2, those orders are the following: the enforcement order, the interim charging order, and the worldwide freezing order, which I've already referred to, again with the page references in the bundle provided, and the further consequential ordering of the sale of the first defendant shares in the second defendant, which I've already referred to. By order dated the 19th of December 2023, again you have the page referencer, with accompanying schedule of reasons of the same date, beginning on page 3680 of the bundle, the court refused to set aside the orders itemised above and ordered the claimant to submit a proposed form of order for sale of the shares. The original application for permission to appeal against the order of the 19th of December was made by appeal notice dated the 22nd of December 2023, which we've termed the original appeal notice.
Michael, to interject, I'm not sure Chief Justice.
Excuse me, Mr. Purchase-Joyce. Sorry,
Yeah.
This is Assistant Registrar Hayley Norton. I believe that the Chief Justice has accidentally disconnected from the call. If you could please just bear with us while we reconnect him. Thank you.
Thank you for drawing that to my attention.
I mean, the last thing you referred to was 39, 36, 78, Mr. Michael.
Thank you. I'm very much obliged. I'll pick up from that point, Your Honour.
Yeah.
That page reference is to the order of the 19th of December, which I'd already referred to in my original submissions. And that order refusing the set-aside application was accompanied by a schedule of reasons of the same date, which begins at page 3680. The original application for permission to appeal against that order was made by appeal notice dated the 22nd of December 2023, which we've abbreviated to the original AN in the rest of the speaking note. The original AN appeal notice was supported by grounds of appeal, again, page reference provided, and they were undated, but I understand that they accompanied the original application. So they would have been submitted as well on the 22nd of December 2023, and a skeleton argument dated the 12th of January 2024, which again we've abbreviated for convenience and given you the page reference where that document begins. The claimant then responded by written submissions, as they're entitled to do, but without obviously putting in any formal skeleton argument. They provided written submissions dated the 1st of February 2024, again with page references provided. The first defendant's original application against the enforcement order and the ancillaries, i.e. all of the orders set out at the top of the page, was dismissed by order dated the 30th of May. The hearing, in fact, was on the 28th of May, so I do need to clarify that. The hearing was the 28th, the order dismissing was made on the 30th of May, with reasons issued on the same date, page references provided. The first defendant made a second, i.e. renewed application for permission to appeal, this application, by appeal notice dated the 24th of June, and we've termed that the renewed AN or appeal notice, time having been extended by application to the court. The renewed
wait. Before you proceed, Mr. Michael,
yes.
Time having been extended by application to the court. Who granted this extension of time?
The court did.
Which court? The registrar? Myself?
Yes, the DIFC registry.
Oh, I think it was your Honour granted
Oh,
that.
it may indeed have been, Your Honour. Yes, I'm happy to be corrected by Mr. Holloway.
That one was to permit you to file the application on that date, not the extension of the 3-week allowed by the rule, because there was some problem with your system or the court system. So I say, okay, you can file in. We treat it as if it was filed in on the day you first attempted to put in.
Yes.
But that is not an extension of the time. Well, I never meant it to be an extension of the time for the 3 weeks allowed by the rules.
Well, Your Honour, I think
because let's take the date that you filed in. That was already past the 3 weeks of 28th of May, wasn't it?
Well, the date runs from the 30th of May, but I accept.
30th of May.
But Your Honour, I think it comes to the same thing, because I've simply taken the date when the formal matter was
Look, B1, I'm using your facts, okay?
Yes.
This is subject to Mr. Holloway, maybe giving an opportunity to comment. D1 made a renewed application PTA against the itemized orders by appeal dated 24th of June.
Yes.
The renewed appeal notice, time having an extent. When was the original, the one that you tried to file in, then there was a messy, there was a problem about the computer system. When was that done?
That was the previous week, and that was in time. So what we had tried to do was we had indeed, as Your Honour rightly recalls, tried to file the renewed PTA application in time, and it was ready to go. And that is when there was a computer glitch on the platform, and we simply weren't able to do it. In order to protect ourselves, we did two things. We wrote to the registry, and we followed up that letter by an application for an extension of time. And the letter, I think, did the trick. But on a belt and braces basis, you made an order, which I think was actually dated the 4th of July. So the order came through after we had, in fact, been able to file. But it was both avenues, both routes leading to the same conclusion. And that was that we were able to file within time. Whether that meant by
within time means within time. When what? Give me a date. Give me a date.
Well,
give me the dates that you wanted to file in.
We were filing within 3 weeks.
3 weeks is the Jeremy Justice Jeremy gave the order on 30th of May.
Yes.
So 18th of May.
No.
18th of June. Sorry, 18th of June.
20th of June.
Oh, 20th of June. Okay, 20th of June. So you 20th of June? No, you put the 24th of June. 24th of June.
Yes, I put the 24th of June in, Your Honour, because that's the formal date when we actually were able to lodge it. But we had been trying to lodge it the previous week within time. And it was at that point that there was a system glitch which prevented us from lodging within time. We did everything we possibly could to lodge within time, and we did nothing other than lodge what we had been trying to lodge within time as soon as practicable thereafter.
Okay, let's done that. Now, tell me,
I think it was, I'm instructed by, or told by my colleague, Ms. Malik, that this was all also shared, Al-Tamimi, the legal representatives of the claimant, were kept informed in real time as to the difficulties that she was experiencing, that her firm was experiencing in lodging the documents, in filing, in making the electronic filing. So my apologies if the date of the 24th has caused a hair to run which needs to be captured. There's nothing in the point, Your Honour, as I understand it. We did try to lodge within time. We wrote appropriately to the court and to the other side, and we sought an extension and obtained an order. So, Your Honour, if I may pass on in the sequence.
Hang on, can you hear me?
I can.
Yes.
You can hear
Yes,
me?
I
Okay.
can.
Can we go wind back a bit? The order of the PTA was the refusal of the permission to appeal by Jeremy was on the 30th of June, 30th of May.
May, yes.
But you were seeking for application to appeal against the order of Jeremy made on the 12th of January. Is that it? No,
No, made on the 19th of December.
19th of December.
Yes.
19th December to the time that you filed the application before Jeremy, that's 6 months. Is that allowed by the rules?
No, it was 6 months between the order which we sought to obtain permission to appeal against and the hearing of that, or the determination of that application. As I've said and made clear in the speaking note.
Again, I want to get the date straight again, okay?
I'm sorry, I've lost sound from the Chief Justice. And his screen is frozen on my screen. Ms. Alia,
Yes, please bear
can
with
you
the registry while we reconnect the Chief Justice.
I never had this sort of problem before. Anyway, yes, let's get to the dates correctly. You were seeking first permission to appeal. First permission to appeal.
Yes.
Before Jeremy, and that was filed in. When was that filed in?
That was filed 3 days after the refusal to set aside. So that was filed on the 22nd of December, 3 days after the original order of the 19th of December.
Okay. 3 days. But the Jeremy did not hear his first application to appeal.
He heard the first application, but it wasn't heard until the 28th of May, and the order refusing that application with reasons was not published or issued until the 30th of May.
Okay. So you are saying now you are all in time. Everything is in time with according to the rules.
Yes, Your Honour.
For me to hear this renewed application to appeal.
Yes, Your Honour.
Mr. Holloway, have you gone through the speaking notes?
Yes, I did.
Can I hear you on that? Is there anything else you want to add, Mr. Michael?
Well, I'd like to go through the speaking note, because what we're doing is
go ahead.
Yes, I'm
please
obliged.
go ahead. Please,
Perhaps,
yes, please.
perhaps, just before that, if I could just say that I have read the speaking note. It was very helpful indeed, Your Honour. But we've been listed for 1 hour for this.
Never
so
mind.
I just wanted to just clarify what the time allocation and estimate would be before we plunge into it.
David, I think we've the screen's frozen again, I'm afraid.
Simple question, might be what you.
Sorry to speak informally, but I think the judge is frozen again.
Yes. Is that all right if we clarify that in advance? I just.
Well, absolutely. I mean, the purpose of the speaking note was really to save time and focus on what we were doing. Because
very helpful.
Alia, can you get an IT man to stand by? An IT.
Yes, of course.
80% to stand by there, please.
Yes.
It cannot go on like this. And Mr. Holloway, I know we have got 1 hour, but I'm ready to give extra time. I don't have anything after this. I don't know about you too, but for me, I'm fine. I want to clear this part because to me it's crucial. I mean, if applications for PTA and all that application were not put on time, then Mr. Michael, you will lose on that ground alone. But if you on that ground, I mean, everything on time, then we go on to the substantial part. And the reason why I'm doing it at this hour with you, I've gone through, I'm a bit confused about the timings and this was by Mr. Holloway in his submission. The preliminary object actually is a preliminary by Mr. Holloway. Okay, Mr. Michael, you proceed on with your submission, and then after that, we'll hear Mr. Holloway. On this preliminary issue first, don't go into the substance yet.
Well, Your Honour, if there is a live issue which is troubling the court about the timing of the renewed application, then I think that should be dealt with now, because no point has ever been taken, and I would be very surprised if we weren't able to move on to the substance.
Mr. Raise this for me.
I'm so sorry, Your Honour. I'm struggling to hear you, to be honest. You're cutting in and out.
I'm having the same difficulty.
Earlier, you tell IT it cannot be my problem or Mr. Patrick Joy's problem or Mr. Holloway's problem, because it's happened to all the three of us. It's not just one person happening over and over again. So it must be your system. Something
Yes, Chief Justice, we're working with IT now.
system earlier.
Yes, Chief Justice, we're working with the IT team.
Just now, I want to go through with this. Have you finished now? Have you finished with that point now? Can I hear Mr. Holloway, or do you want anything else to say? Mr. Michael.
Mr. Patrick Joyce, you're on mute currently.
Sorry, I was on mute. So far as the timing point is concerned, I'm surprised it's been raised. I didn't realize that there was any point there. And I'm more than happy to respond to anything that Mr. Holloway says in relation to timing, but I don't think there's a point which should trouble the court.
Actually, if you his submission, the first 3 points in his submission were these issues before he if you have finished on the preliminary issues, Mr. Patrick, invite Mr. Holloway. Is there anything else you want to say on this?
Well, Mr. Holloway makes 3 threshold points, but they are different from this timing point, and I will respond to those threshold points in the fullness of time, and indeed they are addressed in the further parts of this speaking note.
So, Mr. Holloway, do you want to this again? I just my dates correct. Once I get my dates correct, file on the right date, then everything is okay. But that is very important to me. Holloway, are you there?
Your Honour, we've got something to say about the way that this second appeal has been brought, but I'd rather just leave that to the end and let Mr. Patrick Joyce make the submissions that he wants to make. You did extend time.
Okay, then we'll take the appeal.
I don't dispute that.
We'll take this application as a whole. You know, I was trying to break into 2, hear you first on that issue, and then I make the decision, yes or no. But nevertheless, if that's how you want to go ahead, then okay, Mr. Michael, just proceed with your submission on the speaking notes.
I'm very much obliged.
And then I will hear in full from Mr. But don't worry about the time, because I am delaying it because I'm asking you a lot of questions.
Well, it's always very helpful to have judicial questions because then we know what's troubling the court and can address those issues. But I'm grateful to my learned friend. Mr. Holloway has very properly said and acknowledged that there was an extension of time. So on the time point, I think we can move on. As I understand it, it is accepted to be common ground that it is a non-point. So let me move on now to the substance of the renewed application, which of course is in the form of an appeal notice, and that's sometimes a little bit confusing in relation to terminology. But the renewed appeal notice, as I say at the foot of page 2 of the speaking note, does Your Honour have the speaking note back?
Yeah, I have it here.
Yeah, I'm very much obliged. So the renewed appeal notice was supported by further grounds, and those grounds were directed to explaining why the original reasons given on the 30th of May were wrong. So what you'll see is there's a very substantial continuation of the points being made originally being carried over, saying the court is still wrong in its approach. So the further grounds of appeal dated the 24th of June, a skeleton argument dated the 20th of June, and a third witness statement of Ms. Mansour, which for present purposes, because this is a permission application, and therefore we are looking at questions of arguability, I don't think we'll need to look at, nor will we need to look at the authorities, because obviously the crafting of skeleton arguments is designed to look at the substance of the appeal, and therefore the detail of the substance can be left over again. We're focusing on permission and arguability. Now I pause because I think that the I don't know whether the Chief Justice is able to hear, because you are able to hear, Chief Justice.
Yes.
Good.
I'm good. I can hear you well.
You can hear me well. Thank you for that confirmation. The video is a bit fitful, but as long as you can hear my submissions, that's all that is necessary. To complete the procedural history, the claimant responded to the renewed permission to appeal application by written submissions dated the 12th of July with 3 short supporting appendices. And again, I don't think we need to go into the appendices for present purposes for the same reasons that we don't need to go into the detail of the evidence. Your Honour, let me now turn to the second stage, which is to relate the chronology and sequence of documents that I've just outlined to how they fit in with the present application. There's a bit of duplication, so I'll take it as quickly as I can. Under section 2, paragraph 1, that simply recalls the 3 orders that the Judge, Justice Sir Jeremy Cook, made on the 3rd of February 2023. So there's nothing new there, nor is there anything new in paragraph 2, which is the consequential ability to sell the shares. Then we have the original application notice, nothing new there. At 4, we get to the grounds of appeal, and that sets out the reasons in support of the first defendant's appeal, and for present purposes, application for permission to appeal. And what I've sought to do in paragraph 4 is to summarize the contents of both the grounds of appeal as originally formulated and the skeleton argument as originally formulated. And because of the continuity, there is great importance in going back to what was said back in December last year, because that is, if you like, a golden thread running through the first defendant's case in this regard. And again, just pausing there, the screen has, I think, frozen, but I hope Your Honour is still able to hear my submissions.
I can hear. Good.
Fine. Excellent. Now, if we pause there, the grounds of appeal to the original appeal notice are to be found at page 4034 of the bundle, and that is to be read in conjunction with the sorry, Your Honour, let me just I now need to find a document that there we go. I had them misordered. Your Honour, could I don't know whether you have the grounds of appeal, the original grounds of appeal and the original skeleton argument on behalf of the first defendant in hard copy or only electronically, which would be...
Electronically, I've read through. I've just read through them. That's all. I didn't print any because I thought it's. Never mind. Just go ahead with what you want to say. I'll read them again today. After this.
I'm
if I
very
need
much
to.
obliged. Well, again, summaries are designed to be useful, but not designed to replace. And therefore, everything that I say in paragraph 4 under section 2 is really an attempt to summarize a much fuller exposition in both the grounds of appeal and the skeleton. But the first ground of appeal, and indeed it is relevant to the remainder of the grounds of appeal, and in particular the second and third grounds, depends on Article 7.4 and 7.5 of the Judicial Authority Law, the JAL, which is of course Dubai Law number 12 of 2004 as amended. Now, if Your Honour wishes to find a ready reference to the provisions of the Judicial Authority Law, and it may be convenient now to look at the Judicial Authority Law, could Your Honour turn to page 755 in the bundle?
Yeah, bundle 785. Never mind. Go ahead. Read to me. Read to me. Because I have only one screen here, and that screen is that was emailed to me. Now I don't know whether I can do that on my third screen. I will try to do that.
Well, perhaps I can again. Your Honour has the benefit of the full note, but perhaps I can just read. And Your Honour,
never mind. Your contention, as I understand, is very simple. That the circumstances of these facts, it does not allow a judgment entered into an order made in the Dubai to be enforced in the IFC. That's the crux of your argument, right?
The argument is a little bit more.
Now you're going to give the reasons why you say so. You're going to give reasons why you say so now.
Well, Judge, I'm not saying that a judgment of the Dubai courts cannot be executed in the DIFC courts. But what I am saying is that the provisions of Article 7 of the JAL, and in particular Articles 7.4 and 7.5, must be read and respected.
Okay.
Now, let me begin with Article 7.4. Your Honour will be familiar, so I'll read it quite quickly. But Article 7.4 begins with very important words which are specific to Article 7.4. And those words are, where the subject matter of execution is situated in the DIFC. So, those words condition the rest of Article 7.4, and there have to be, therefore, assets, the subject matter, against which execution can be made in the DIFC. And what we say is that that is simply not possible on the present facts. The reason
the shares are in the IFC.
the shares are
the company.
The shares are in the DIFC, but
yes,
it is not possible under Dubai law to execute against those shares because it is contrary to onshore Dubai law to do so, and the Dubai courts have written consistently to the DIFC courts to that effect. So there is the shares.
The issue whether is yeah, whether it's yeah. Go on, please.
The shares are not assets against which execution can be levied. And it's only the shares which are in the DIFC, because the property owned by D2 is all onshore Dubai. So the only asset against which execution can be levied in the DIFC jurisdiction are shares, but the Dubai law specifically prohibits execution against those shares because they're shares, excuse me, in a private company. And the Dubai court has written consistently a series of letters to the DIFC courts saying those assets are not assets against which execution can be made. So that is the importance of the introductory words of Article 7.4. Now, then it goes on to what would happen in terms of execution, but we say we don't need to go beyond that because there is nothing in the DIFC against which execution can properly be raised. Then Article 7.5 says as follows: in addition to paragraphs A, B, and C of clause 4, which for convenience and time I've skipped over, when executing through the courts the judgments, decisions, or orders issued by Dubai courts and arbitral awards ratified by Dubai courts, the following must be observed. A, the Dubai courts shall issue an execution letter to the Chief Justice of the courts stating the procedure to be carried out. So that is the execution procedure, which is identified by the judgment court, not the executing court. B, the person requesting execution shall submit to the execution judge of the courts an application accompanied by a copy of the judgment, decision, or order, legal translation of the same, and the execution letter. And then we have a very important provision. C, the execution judge of the courts, here the DIFC courts, shall apply two things: the execution procedure and rules stipulated in the rules of the courts. Now, my learned friend seems to say, well, once it's within the DIFC, then DIFC rules apply. But that isn't what subparagraph C says. Because if the learned friend...
Read subparagraph C again to me, please.
Yes, the execution judge of the courts shall apply, mandatory, shall apply the execution procedure and rules stipulated in the rules of the courts. So there are two things that need to be applied.
Rules whose court? Rules of whose court?
The DIFC court.
Yes, so, yes, go on.
Well, because...
How do you relate that to the Dubai courts? You say follow everything in the DIFC courts, isn't it? Okay, never mind. Sorry, go on.
No, Your Honor, it isn't.
No,
it
I
isn't.
didn't.
It isn't.
Okay.
And this is very important.
I must understand you correctly. Yeah.
Yes, it is very important because this is the crux of the first defendant's case and why, in fact, the claimant's case is wrong. But that's a matter for the substantive appeal. All we need to establish is arguability at this stage.
Yes.
So what Article 7.5c says, and I'll take it very slowly, and we may have to go over it 3 or 4 times.
Okay.
The execution judge of the court, so the execution judge in the DIFC courts, shall apply, and then the next words are the execution procedure. Now, what do those words mean? Well, those words mean, or the meaning of those words is clearly informed by what Article 7.5a says. And just to remind you and the court of what Article 7.5a said, it's as follows: the Dubai courts shall issue an execution letter to the Chief Justice of the courts, the DIFC courts, stating the procedure to be carried out. So what happens is the Dubai courts write to the DIFC courts stating the procedure to be carried out in the execution of their judgment, i.e. execution procedure. And then what, taking that from 7.5a and applying it to 7.5c, what must the execution judge in the DIFC courts do? And he or she must do as follows. The execution judge of the courts shall apply the execution procedure. So the primary obligation
You
on
are saying the execution procedure is the execution procedure of the Dubai courts.
Of course,
that's what you're saying. That's what you're saying.
Of
but
course.
But how does the Dubai court control the DIFC courts? How it executes? How the DIFC courts is to execute the judgment? The real objective is so that the creditor, the claimant in this case, gets what is due to him. Basically, that's what you want to do. So if the money is in my hands, I'll just ensure that you get the cash from me. How I do it is my business. But if you are going to tell me how I am to dispose of these assets in my hands, you do not know what the rules in my courts are. You do not know. Dubai courts doesn't know how the IFC court functions. I mean, it goes against my common sense. I'm sorry to say so.
No, Your Honor, the point actually arises at an earlier stage because the whole mechanism of Article 7.5 is, first of all, to identify what I can term executable assets, assets against which execution can be levied, and non-executable assets, i.e. assets against which execution cannot be levied. And if the Dubai court says, as part of its instructions on execution procedure, that certain assets are not capable of execution, then that must be followed by the DIFC courts. For all assets against which execution can be levied, then execution is levied by the DIFC courts. But what Articles 7.5a and 7.5c do, particularly when applied to the particular facts of this case, is to differentiate between non-executable assets, which are the subject of the execution procedure, and executable assets, which are subject to execution in the ordinary course of events. So with non-executable assets, you don't even get onto the starting point of execution. There cannot be execution against non-executable assets. And that is the whole nub of this case. And that, we say, is plainly arguable. We go much further. We say that by construing Article 7.5, as one must, by reading it in its totality, and not looking at bits in isolation. When you look at Article 7.5 in its totality, its meaning is clear. So we go way beyond arguability, but we don't need to for present purposes.
Can you help me with maybe an authority in England or something that applies this sort of principle, that the execution follows the procedure set by the court that made the order, the judgment, or gave the order for the judgment?
Well, of course.
Something that, to me, I don't know. I know at this stage, it's not my duty to decide the law yet. My duty is just to hear you and decide the real prospect of success.
Yes.
Is there a real prospect of success if the matter goes to appeal? That's my duty here. That's all. Nothing more than that.
Something which, a prospect which isn't fanciful. Yes, a real prospect.
Yes, it's not fanciful and things like that. So as I said to you, what's in my mind now is that it's too fanciful to apply that principle, that interpretation that you just suggested.
Well, Your Honor,
Never mind, never mind. I will
well,
decide. I'm
well,
giving you all the opportunities to tell me I'm wrong.
and
I will tell you I'm wrong.
may I accept that invitation, Chief Justice?
Sure.
The first point in accepting your invitation is to go back to say that Article 5 must be read and construed as a whole. So therefore, what is meant by the terms execution procedure in Article 7.5c is clearly informed by the definition of procedure, which is derived from Article 7.5a. Now, that is the first point, beyond which I really don't need to step, but I shall, for one purpose, because Your Honour says, is there an English law case which establishes if you like, the balance of allocation, such as we have in not a DIFC law, but a Dubai law. One must remember that the Judicial Authority law is a Dubai law, and the intention of the JAL is to allocate jurisdiction within the same emirate between two courts. And it is therefore exceptional. It is highly nuanced and detailed, and it is a delicate balance which needs to be maintained. And that is why you have to go back to the law itself. You have to understand in my submission the context in which the law was passed. Originally in 2004, and it'll be said Article 7 was expanded and amended in 2011. Indeed it was, but it was expanded to cope with just these sorts of nuances which emerge. And that therefore one must, in my submission, look both at what the legislative provision says, that's the first point, and secondly, put that in context. And the third point, to go back to Article 7.5c, is to read it in its entirety. Or read the first sentence in its entirety. We don't need to worry about the second sentence of Article 7.5c. The first sentence of Article 7.5c in its entirety reads, "The execution judge of the court shall apply the execution procedure and rules stipulated in the rules of the courts." Now, if my learned friend were correct, there are some entirely redundant words in Article 7.5c, because if my learned friend is correct, Article 7.5c could simply say the execution judge of the courts shall apply the rules stipulated in the rules of the courts. Now, it doesn't say that. And a legislative drafter who has amended the legislation in 2011 for specific reasons must, in our submission, be taken to have intended that the words used carried a meaning and did not slip in redundant words for the sake of utter confusion. And therefore, it is critically important that Article 7.5c is properly construed. A, within the four corners of what Article 7.5c says. B, within the four corners of the judicial authority law and the entirety of Article 7. C, within the broader context of the delicate balance which needs to be established between the Dubai courts and the DIFC courts. And fourthly, on the basis that a legislative drafter does not introduce gratuitously entirely superfluous words. So in essence, Your Honour, there are 4 routes, all of which lead, for present purposes, to arguability, and which we say at the substantive appeal will result in the appeal being allowed.
Okay, understand what you're saying.
So, Your Honour, having taken, Your Honour, to the law, may I go back to the speaking note, and we'll see how that fits into the speaking note. And again, I've provided references to the skeleton arguments. I'm happy to take, Your Honour, to the grounds of appeal and the skeleton argument. And it may be important just to look at things as we go through. So picking it up at the foot of page 3 of the speaking note, paragraph 4.1, articles 7.4 and 7.5 of Dubai of the JAL defined the DIFC court's relevant jurisdiction, didn't simply set out guidelines as to how that jurisdiction should be exercised. Your Honour has my submissions based on the law, and if one goes to the grounds of appeal, paragraph 1 of the grounds of appeal, which begins at the foot of page 4034 and goes down to the foot of page 4035, says that the learned judge erred in concluding that paragraph 7.4 and 7.5 do not go to the existence of the DIFC court's jurisdiction to recognise and enforce judgments of the Dubai courts. They're only relevant to the manner in which jurisdiction should be exercised. So that is how the judge erred. The basis upon which the claimant asserts the DIFC court had jurisdiction was expressly premised on Articles 7.4 and 7.5. The only conceivable route is Article 5A1E of the court's law, and the court's power to ratify judgments at Article 24. I comment on ratification further subsequently. Arises pursuant to Article 7.4. The jurisdiction, the DIFC court's jurisdiction to ratify and enforce Dubai court judgments therefore arises pursuant to 7.4 and 7.5. The jurisdiction of the DIFC court is exclusively statutory. DIFC court must establish a relevant gateway, and therefore, unless the claimant can establish jurisdiction under Article 7.4 and 7.5, the DIFC court has no jurisdiction. We've looked at Article 7.4 and 7.5, and that has made good the submission set out there. Article 7.1, which the claimant does rely on as well, is irrelevant because Article 7.1 is concerned with with judgments, decisions, and orders rendered by the courts and arbitral tribunals sorry. Article. Let me go. It's easier if I go back to the grounds of appeal. G. Article 7.1 is irrelevant since it only concerns the DIFC court's power to execute judgments rendered by the courts, i.e. the courts of first instance and court of appeal, established by under Article 3 of the JAL, and not the Dubai courts. So Article 7.1 does not apply because it applies to DIFC court judgments, not Dubai court judgments. And therefore, the learned judge should have found that unless the mandatory requirements at 7.4 and 7.5 were met, the DIFC court had no jurisdiction. And just picking that up at 4046, the judge's consideration of the DIFC court's jurisdiction was at paragraphs 3 to 12 of the original schedule of reasons, and it's explained in paragraph 18 by reference to Sandra Holding that the court had erred in that regard, and then we get into the detail of articles 7.4 and 7.5 in paragraph 22, which I've really already taken the court to. And we then have a consideration of Article 24 of the DIFC court law, and it said that that doesn't assist. And it doesn't assist for two reasons. One is it's, if you like, a subordinate legislation, because it's not a Dubai law, it's only a DIFC law, and it is expressly said to be pursuant to Article 7.4 of the JAL, and that was a reference to the original Article 7.4, and that should now be read as a reference to Articles 7.4 to 7.5. So we've set out in quite extensive reasons the arguments in support of what I have just said. If we go back to the speaking note at the head of page 4, the second ground of appeal is that the, and again, may I just check that you're back with the speaking note, Your Honour? Yes. The DIFC court, I'm obliged, the DIFC court erred in law in concluding that there was no need for any asset to be within the DIFC jurisdiction. And that goes back to the importance of the opening words of Article 7.4, and you have that point. Point 3, the DIFC court erred in law in giving an expansive scope and meaning to Article 7.5a of the JAL. Well, that's how, in fact, it's probably more appropriate to focus on 7.5c, but that's back to the interrelationship between 7.5a and 7.5c, and how 7.5a clearly informs the meaning, scope, and effect of Article 7.5c. Point 4, and this is moving away from the JAL, the DIFC court erred in fact and law in not giving due weight to the execution judgment of the Dubai courts and in its consideration and application of Federal Decree number 32 of 2021, the Commercial Companies Law. Now, very briefly here, it's the interplay between the Commercial Companies Law and other Dubai onshore provisions which give rise to the difficulties as between assets against which execution can be levied and assets against which execution cannot be levied. And by looking at the companies law and related legislation onshore, there is scope for argument. And we'll come back to this, if I may, because that point is more clearly articulated in the original application for permission to appeal. And the learned judge, Justice Jeremy Cook, has something to say about this aspect. And he sees that it is that there is plain room for argument. I'll make that good in due course. Point 5, the DIFC court's decision was unjust by reason of other serious or procedural irregularities. That's essentially the fact that evidence was admitted as to the meaning of the Arabic word amwal, as to whether it meant funds or whether it meant assets, and essentially whether it was limited in the scope of execution. And there was late evidence which was adduced, which went to that point, and we say that was unjust and unfair. If that were a standalone point, then it might not carry me home, but it certainly does support the conclusion that I urge upon this court as part of the collective whole of the first defendant's case. And the 6th point is that the DIFC court erred in law and fact in finding that it was not restricted by the terms of the execution letters sent by the Dubai courts to the DIFC courts. And again, that is part and parcel of the proper interpretation and construction of Article 7.5, which we've seen, and which again, all of these points are elaborated in the grounds of appeal as originally formulated or the original grounds of appeal and the original skeleton argument. The relevant factual background, and I probably don't need to take Your Honour to this, but for Your Honour's note and reference, the factual background is summarised in paragraphs 4 to 10 of the skeleton argument to the original appeal notice. Again, references given. The skeleton argument tied the argument back to the relevant paragraphs of the schedule of reasons, and again, you can see that by looking at the skeleton argument, but I think Your Honour has indicated you've had a chance to look at that already. Let me now turn to the next document in sequence, which is the claimant's original written submissions, WS written submissions in response. And I've given, again, the page reference to that. It begins at page 4088, runs to some 23 pages. Now, what we say is if you take 23 pages to say something is unarguable, then that in itself is a matter of surprise. But that is a pure quantitative argument. And it's important that we go beyond that and drill into what is actually said. Now, in the time available, I can't go into the details of the written submissions in the way that I would in a substantive appeal. So what I've done is taken one example. If we go over to the top of page 5 of the speaking note, at this point, I've been too elliptical in what I've said. Could you, when you look at the top of page 5, it says grounds 1 and 2 of D1's grounds of appeal depends on treating a judgment of the Dubai courts as a foreign judgment. Now, strictly, that is not right, because we do not treat a judgment of the Dubai courts as a foreign judgment. The point is that claimants' written submissions in response to our grounds 1 and 2 depend on treating a judgment of the Dubai courts as a foreign judgment. So what I'm saying here is directed to the claimant's written submissions in response, because what we then say in the short sentence, it is not, it is not on our case right to say that a judgment of the Dubai courts is a foreign judgment. If that were right, and again, the need to construe Article 7 in particular in its entirety, if that were right, then Article 7 could be expressed much more succinctly and much more clearly, because there would be absolutely no reason for drawing a distinction between the judgment of the Dubai courts on the one hand and judgments of and foreign judgments on the other. And that distinction is clearly drawn in Article 7 of the JAL as it is drafted. And so that's the point we make in the next sentence. That is precisely why the JAL differentiates between judgments of the Dubai courts and foreign judgments. So what the claimant's written submissions and the claimant's case as a whole totally overlooks is this fundamental difference. It's not only inconvenient for the claimant, but that would be sufficient to satisfy the arguability test. We say it really destroys the whole of the claimant's argument. So therefore, and I think what I've done, have I done it here or elsewhere? Let me just take you to the claimant's no, I think I can make that good more clearly by reference subsequently. But let me just reiterate that what the claimants do is they conflate judgments of the Dubai courts and foreign judgments, and say they're indistinguishable for the purposes of execution enforcement. That's not what the judicial authority law says. Paragraph 8, this goes back to what happened in the original PTA application. The original PTA application was dealt with by the court without argument. And if one looks at page 4735.
Yeah, but the judge considered the written submission of the PTA, although he didn't grant the adjournment, but he said he read through the written submission and made a decision based on the written submission.
Well, it is said that he has looked at the written submissions of the parties. I accept that. But what he doesn't go on to explain is why the written submissions of the first defendant were wrong. And that's the problem. So, and that's the value, of course, of this oral renewed hearing, because one can actually get to grips with the nub of the issue. And unless a court, in my submission, is taken to Article 7, particularly Article 7.4 and 7.5, it's almost a case of, it's not familiarity breeds contempt, but familiarity breeds perhaps complacency and an understanding or a belief that Article 7.4 and 7.5 says one thing, but when you're actually taken to Article 7.4 and 7.5,
yeah, I think you have made yourself clear on that point. I don't think we need to go through that again.
Good. And what we say is that therefore, the first time round, the court, going back to paragraph 8, the court dealt with the application summarily and with very short reasons, as one might expect. We've identified the context in which it was made, and the court's reasons are summarized in paragraph 31 of the first defendant's skeleton argument to the renewed application or appeal notice. Then we provide the fact that the PTA application has been renewed. In support of the renewed application, the grounds of appeal, this is paragraph 10, sought to explain why the short reasons given on the 30th of May 2024 were wrong. Now, my learned friend criticizes the first defendant for doing this, but in my submission, it's eminently appropriate for the course that we followed to be followed, because having given reasons, albeit short and albeit we say wrong, if we simply overlooked those reasons and didn't respond to them at all, then the court would be left in a quandary. It would be left asking itself whether we'd were just ignoring those reasons, whether we hadn't addressed our mind to those reasons, whether those reasons held good, etc. So we had to go beyond what we were saying in the original grounds of appeal and skeleton argument to show that we had purposefully and constructively considered what Justice Sir Jeremy Cook had said and had written in his schedule of reasons on the 30th of May, and that notwithstanding that consideration, our application for permission to appeal was still well grounded. So that's what we've done. And of course, that is why in the renewed grounds of appeal and the renewed skeleton argument, we make very clear that this is a continuation of the bases on which the matter was originally put. And that we make express in the remainder of paragraph 10 with quite copious page references. But I think the point is so self-evident, I don't need to take you to those page references.
I think you have made what you have said in the speaking notes is a repetition of what you have said earlier.
It may be, and I'll go therefore more quickly. But he pointed paragraph 11.
Have you mentioned all this? You mentioned.
Well, paragraph 11 is important, Your Honour, because what we say there is that the court is invited to pay particular regard to the acknowledgement that there is plainly room for argument. And this is to be found in paragraph 13 of Justice Sir Jeremy Cook's reasons on the 30th of May, and the particular page in the bundle is 4736. 4736. And here at paragraph 13, let me read it into the record. He says, there is plainly room for argument about the effect of the decisions of the onshore Dubai court, the translations thereof and their meaning, and the effect of Federal Decree Law number 32 of 2021, and the terms of Article 20, which is again another domestic provision in Dubai, onshore Dubai law, particularly in relation to shares in private companies as opposed to shares in listed company, a point now made express in the defendant's application. So just standing back there, what is the judge finding that there is plain arguability in respect of? He is finding plain arguability about the effect of decisions of the onshore Dubai court. So that's the first element of plain arguability. He's finding plain arguability about translations thereof and their meaning. So bundling translations and meaning together, that is a second aspect of plain arguability. Then he goes on to the effect of Federal Decree Law number 32 of 2021. Now that is a separate head of plain arguability, because that is plain arguability which goes to the meaning and effect not of court decisions onshore, but of primary onshore legislation. So that's a third aspect of plain arguability. And the plain arguability with regard to the onshore law is itself twofold, because it is about the effect of the Federal Decree Law and Article 20 in relation to both shares in a private company as opposed to shares in a listed company. So maybe that's just one point because you have to differentiate one from t'other. But there are several grounds on which the learned justice found plain room for argument.
Okay, can you go to the next point? Execution letters. Execution letters, your paragraph.
Yes,
I
indeed.
think you have already said this earlier on.
Let me go to the, let me take you to pages 6345 to 6349. And I need to go get those up myself. Now, what we have here, Your Honour, is a translation from the Dubai courts of letters which were addressed by the Dubai courts to the DIFC courts concerning the non-executability of the shares in support of or in discharge of the judgment debt. So we have the original execution letter of the 31st of January, which isn't actually on this list, but I can provide a cross-reference to that should the court wish it. But then there was, subsequent to the 31st of January, the Dubai courts wrote on the 9th of May, drawing attention to the fact that on the 25th of April, the Dubai Court of First Instance had decided to address you, in terms of your office, Chief Justice, address the Chief Justice of the Dubai Financial Courts on the operative part of the judgment, based on the decision of the honoured execution judgment. And we can look at that if need be, but I think we probably are better served looking at it in the context of a substantive appeal. Then on the 1st of August 2023, the Dubai courts wrote again to the DIFC, saying that on the 31st of July last year, they had decided to address the DIFC courts, requesting to lift the freeze imposed on the shares of the judgment debtor in HMR, which is D2. And the reason for that lifting is because of the non-executability against that asset. Then on the 15th of August 2023, the Dubai court again wrote to you in your official capacity, not personally, saying that the Dubai Court of First Instance has decided on the 15th of August to address you, requesting to lift the freeze imposed on the shares of the judgment debtor in D2. Then on the 18th of September, there was a follow-up letter referring to our previous letter, which is the letter of the 15th of August, a copy of which is attached. The Dubai Court of First Instance decided to address you to provide us with information about the attachments that have been imposed on the above debt. Going on to the next page, the Dubai courts again wrote to you in an official capacity on the 28th of November 2023. Reference is made to our letter dated the 18th of September. On the 27th of November, the Dubai Court of First Commercial Instance decided to send you a letter to accelerate your reply regarding the requests in the aforementioned letter. Attached is a copy thereof. And then on the 2nd of February this year, again, the Dubai court wrote to you in your official capacity. We inform you of the decision issued on the 2nd of February 2024, requesting you to direct the concerned parties to execute where it contained, which is as follows. Referring to our letter sent to you on the 31st of January, which is the original execution letter, based on the decision issued on the 24th of January regarding deputization, which states the IFC courts are authorized to impose an attachment on any funds belonging to the judgment debtor within the limits of the claim amount, taking the procedures into consideration. Important words, taking the procedures into consideration. Please be advised that the execution should be based on the aforementioned decision, on the funds of the judgment debtor, excluding his shares in D2, details of which are provided. Whereas a judgment which was issued on the 2nd of November 2022, the court accepted the appeal in form and on the merit by cancelling that earlier decision, ruled again to reject the request for the sale of the appellant's shares in D2. So consistently, not only has the Dubai court said that these shares cannot be sold and there can be no execution against these shares, the Dubai courts have drawn this formally, appropriately, pursuant to the protocol between the courts and also the terms of the primary legislation, the judicial authority law, to the attention of the DIFC courts. And then further, a subsequent judgment was issued on the 26th of July, case number given. The court accepted the appeal in form and on the merits by cancelling the appeal decision and ruled again to lift the freeze imposed on the appellant shares in D2, etc., etc. Please instruct the concerned parties and inform us of the response according to what is mentioned above with appropriate attachments. And then finally, so far as this table is concerned, on the 15th of May this year, the Dubai Court of First Instance, again, this is correspondence emanating from the Dubai court sent to the DIFC court, the Dubai Court of First Instance decided on the 13th of May 2024 to address you to inquire about the outcomes of the delegation procedures relating to the attachment of the defendant's funds located within the DIFC as determined by decision 180 in the present execution file in accordance with paragraph 3 of article 208 of the Federal Civil Procedures Law. This article clarifies the procedural relationship between the competent court and the delegated court as follows. The execution judge who carried out the delegation informs the competent execution judge of what has been done, transfers any item received or other funds resulting from the sale of the attached assets. This is due to the authority and supervisory jurisdiction of His Excellency the execution judge as the competent judge over the actions of the delegated authority, considering this matter as an obligation of the Dubai International Financial Centre courts to ensure their compliance with the procedures and implementation of the directions of the delegation issued by the Dubai courts. So, if I can just get back.
You are saying from the letters that you read just now that the Dubai court is telling the DIFC courts that the DIFC court cannot execute or
Yes.
make an order of execution against the shares. Is that what you're saying?
Absolutely. They have done that consistently and repeatedly. And that is part and parcel of the execution procedure, which is provided expressly by Article 74A, 75A, and read into 75C of the JAL. That is precisely the position, Your Honour.
Let me read through. I must confess, I didn't go through that detail. I must read through the letters again. What did Justice Jeremy say in respect of those letters? What did he say? How did he rule them?
I don't think that I'll be prompted if I'm wrong, but I don't. He says, well, what he says is paragraph 15, which is page 4736. He said it's clear that the terms of the execution letter cannot be limited to cash or its equivalent, whatever the position with regard to shares in the second defendant. So what we say is that that is actually rather important, because he is acknowledging that there is arguability over the position with regard to shares in the second defendant. And that is the only asset in the DIFC. So he is, if you like, setting up an armed sally.
Is this where he used the plainly room for argument? Is that the context he was saying? Or is
Well, it follows on from that. It's on the same page. The plain room for argument is paragraph 13 of his reasons, page 4736. And later on the same page, he looks at only one, the execution letter, and says, without reference to any of the other letters, cannot be limited to cash or its equivalent, whatever the position with regard to shares in the second defendant. And that, of course, is part and parcel of what we say in our written submissions.
Okay.
That we make the point, paragraph, page 4752, in our grounds of appeal, or renewed grounds of appeal. We say, having concluded that the, quote, new arguments plainly gave room for argument about the effect of Dubai legislation, the court erred and was wrong in law to find that insufficient to affect the view that it had previously formed. Plain room for argument must mean that D1's stance is plainly arguable. Plain arguability is more than mere arguability and must connote a real as opposed to fanciful prospect of success.
I think you have said enough, Mr. Michael. Can I now hear what Mr. Holloway has to say? Because the rest of your speaking notes is just saying the same thing again.
Yes, there is one point, and and that is that my co-counsel, Miss Malik, is in Dubai, which makes it rather difficult for her metaphorically to tug my gown, and I'm not too sure whether she would wish to follow on any particular point, obviously very shortly in view of what
I think you have already made your points very well, Mr. Michael. I think I will invite Mr. Holloway to, if she has anything to say, she can say at the end of the this hearing.
Yes.
Mr. Holloway, I think
Well, could
how
I,
long I think you can
Yeah.
finish quite quickly, isn't it? Half an hour, 45 minutes, or half an hour, 40 minutes.
could
I
I,
think you can.
could I ask for just 1 to 2 minute comfort break?
Sure. Sure, please do. Let's take a 5 minutes break. 5 minutes break.
Thank you.
I
I'm
won't turn
obliged,
off the
and
screen.
that enables me to take instructions as well.
Indeed.
Yes, please do. Okay, I'm
Thank you,
going
Your
to keep the link on, but I'll take out the camera and the microphone as well.
Yes. Grateful
Okay,
for that.
let's wait for him.
If Mr. Pachitos has anything else, I'm very happy for him to add it before I start.
Sure.
No, I'm very happy to yield the floor to my learned friend.
Okay, thank you very much. Okay, Mr. Holloway.
So, Your Honour, just what I'll do is just some preliminary background remarks just from our side of the table. I'll delve into the jurisdiction point, and then I'm going to talk about some of the threshold points as well. Just by way of deep background, Mr. Rashed is a recalcitrant judgment debtor. This whole application has been to enforce a judgment that was originally made in 2016 and has not been complied with. In fact, all means have been deployed to avoid complying with it. Your Honour, you picked up on the fact that the original orders made by Sir Jeremy Cook were made in February 2023. They were made ex parte. There was a return date in March 2023, which is over a year and a half ago. Mr. Rashed didn't attend that return date and made no attempt to set aside the orders until over 6 months later, by which time he had deployed considerable resources in the onshore courts trying to generate correspondence, letters and orders that might assist him. So he boycotted these proceedings. He didn't comply with the freezing order, and that led to him being committed for contempt in November of last year. And I'm not going to I'll deal with contempt at the end. I'll come back to it. But at that point, the initial sanction at the contempt hearing was that Mr. Rashed was not allowed to participate in these proceedings to take any steps apart from arguing that the court lacked prima facie jurisdiction. He was given a chance to purge his contempt. He's been given several opportunities to do so by Sir Jeremy Cook, but he has not done so. So the important point is that that committal hearing led to a sanction, that the only issue that we can debate in this case further is the fundamental question of prima facie jurisdiction. Is there a gateway? Have we cleared that gateway? And as a threshold point, all of the things that Mr. Patrick Joyce were talking about were not about jurisdiction at all, but about procedure. Talking about the procedure of execution and talking about decisions and letters in the Dubai courts about execution, which are all procedural matters. They're not jurisdictional matters. That's what Sir Jeremy Cook found, and there's no real prospect of getting around that. The other just first point I'd make is Mr. Panchos kept talking about the test of arguability, he says. In other words, you're allowed to appeal a decision as long as you come up with something to argue about. Well, we could all debate the intricacies of onshore law and onshore decisions to the cars come out. It's not arguability that is the test, the real prospect of success. That's what's said in the rules. And our skeleton argument set that out very clearly. It's more than mere arguability. You have to be convinced that there's something to argue about on the jurisdictional ground. And there are three different limbs to that. For example, when he says that the decision was procedurally wrong, that's an even higher standard to meet. And we've set that out in our skeleton argument as well. when he's talking about the factual conclusions reached by Sir Jeremy Cook about the meaning of the execution letter, he has to show that that was plainly or obviously wrong. He can't come anywhere near to meet those tests. So it's not, we shouldn't be here discussing whether there is something to argue about in this case. We have to say, is there a fundamentally obvious, clear point that was wrong on the jurisdictional issue? And
Mr. Patrick Joyce's argument was on the interpretation of 7.4 and 7.5, JAL 7.4 and 7.5. And he's saying that, the issue of assets must be in the IFC, and the issue of the procedure has to be, you have to follow the as directed by the Dubai courts.
well, yes.
Why don't you zoom on those points? Those are the things that is
I will zoom
in my mind now.
In more detail, but what I was trying to just get to at the beginning is that it is the jurisdictional issue that needs to be, there has to be a real prospect of success, that this court, what he's saying is that this court cannot enforce a Dubai judgment. It cannot execute against assets in the DIFC. Not only can it not, but that it has no jurisdiction to do so. And in my submission, that's fundamentally unarguable. I will tell you in detail why, because I'm going there next. But when you look at all of the instruments, it's absolutely clear that the DIFC court does have jurisdiction to ratify, recognise and enforce a Dubai judgment. And once it has done so, it can execute in the DIFC according to the procedures that it has in the DIFC.
Okay, before you proceed, Mr. Holloway, I forgot to ask Mr. Patrick Joyce just now that you mentioned something like because he has not purged his contempt, he should not even be heard now.
Well, I don't go that far.
Something like that in your judgment, in your submission.
No, my submission is that he can only be heard on questions of prima facie jurisdiction. Now,
yes,
what I'm actually saying is that all the arguments that he's running are not about prima facie jurisdiction, they're about procedure. And the letters that the Dubai court wrote and the Dubai judgments and matters of onshore law, they're all procedural questions. They're about how to do things. They're not about the court's fundamental ability and power to do it. So to the extent that they don't go to jurisdiction, to the extent that they are procedural questions, he cannot argue them. Now, that is a consequence of his own contempt of court, Your Honour. And I have to remind everyone that that contempt of court order was made in November. At that point, Mr. Rashed was represented by an international law firm, an experienced counsel. It was a hard-fought application. You'll see in this bundle there are nearly 1,000 pages of paper devoted to it. That application went against him. He did not appeal it. He never even applied for permission to appeal it. He stuck with the consequences of his own contempt. So as far as these are jurisdictional questions, yes. As far as they're procedural questions, no. And Sir Jeremy Cook's judgment clearly stated that the Dubai 7.4 and 7.5 are procedural matters, that the Dubai Court of Appeal decision and execution is a procedural decision limited to Dubai and the way that it executes things, and that the letters from the court are likewise procedural, but they don't go to the court's prima facie jurisdiction. So the question, does this court have prima facie jurisdiction to recognise, ratify and enforce a Dubai judgment? The answer must be yes, for the simple reason that there's nobody in Dubai has ever said that this judgment is in any way flawed, defective, and that he doesn't owe that money. He owes that money. The Dubai courts have tried to collect it. They have failed. We are trying to collect it in the DIFC because assets are in the DIFC, and this court has unfettered jurisdiction in the DIFC to execute the judgment. Not only can it do, but it should do that. Now, a couple more background points, Your Honour, before I get in. There was no question that all the formalities to enforce this judgment were complied with at the time the orders were made and at the time of the return date. So the judgment that was attached, it had the executory formula. There was an execution letter from the Dubai courts. And my lord, that's, the judgment has the stamp saying that it is executable. That's never been questioned or withdrawn by the Dubai courts. And there was an execution letter saying that all the enforcement could take place against all assets in the DIFC. Now, that's that's what happened in February. The first step that we take enforcing and executing a Dubai judgment is recognition. That was the enforcement order. The charging order was subsequent to that, a post-DIFC judgment charging order. The freezing order was to protect assets held by the company, which Mr. Rashed had previously dissipated into the company. Now, there's no basis on which the enforcement order can be set aside because the judgment is enforceable. The charging order and the freezing order follow from that. And the fact that the Dubai courts did not execute over the shares of Mr. Rashed is really irrelevant, first of all. And Sir Jeremy Cook found it to be irrelevant because he found it to be a procedural decision of the Dubai courts in execution, no barrier to the substantive judgment being enforced and executed in the DIFC. But importantly, just by way of background, in February and at the return date in March, the court was well aware that the Dubai courts would not execute against these shares. The judgment was put in front of the judge. It was discussed at the hearing, at the ex-parte hearing. At the return date in March, there was every opportunity for that argument to be raised, and it wasn't. Raising it 6 months later is too late, and I'll come back to that at the end. That's the final threshold point. But at the point where the enforcement order was made, Sir Jeremy Cook was aware that the Dubai courts were not executing over the shares. He was also aware that the defendants had written to the Dubai courts asking them to write to the DIFC courts to cancel the freezing order. That was before the return date.
Can you help me?
Yes.
Why did the Dubai court not want to execute against the shares?
That is the decision that Jeremy Cook said was arguable. We can debate the reasons for that, but looking at the judgment and the law, it's simply, I mean, I can take you straight through to that, Your Honour, if it would be helpful.
Yes, please.
So, first of all, I mean, I'll come back to this. This is the crux of the problem that the defendant has tried to create here. There was a decision saying we cannot sell the share. And what they're trying to inflate that to mean is that you cannot sell the share in the DIFC court. They're two very different things. But it is important. Let's look at the judgment.
Or they're saying that you can sell in the IFC but not in Dubai.
They're not saying anything. They're just saying a decision was made and we have overturned it with very little reasoning. But I'll take you to that actually.
Yes, please.
Because it actually is important. It's the decision is at page 3. The original decision is at page 378.
At page 378.
Yes.
Okay.
And the original decision was 6 lines long.
6 lines long.
Yes. It says we authorized the sale of the share significantly of the execution debtor in the company, as stated, for market value, and we reject all other requests. As simple as that. And that decision was then overturned And it's this Court of Appeal decision, I think, that has led to the mischief making that's gone on, really, if I can put it that way.
Oh, the order was made by the onshore courts in Dubai
Yes,
to sell or not to
yes.
sell.
And this is there's a long history to this. I'll try and cut it short. But they originally wrote to the DIFC court and said, how do we sell shares to execute a judgment? And the DIFC authority wrote back saying, we don't sell shares. And I think the claimant's lawyers at that time thought, well, we've got to do it through the Dubai courts. They applied to the Dubai courts. There was an order made to sell the shares, but the Court of Appeal overturned it and said, we cannot sell the shares. Now, the obvious reason why they wouldn't be able to do that is because it's a DIFC company, but it doesn't say that in the judgment, and that's what's caused all the mischief. Now, let's. It's at 380, the Court of Appeal decision. I think this is the root cause of the mischief, I think, if I can put it that way. Going down the page, the operative, where does it say, in light of the above? Yes. At the third paragraph on that page, 382, sorry. The conclusion here, and this is what Jeremy Cook says, we can argue about this, and indeed we probably could argue about this because it's very opaque. But it says, it is confirmed upon reviewing DIFC license that HMR is a private company and not a limited company.
Yes,
So the
listed company.
No,
it's not a listed company.
Oh, it's not.
It's not even limited company.
It is. It is
not a listed company.
It is a limited company as we understand it in the DIFC. It is not a listed company, but it is not technically an LLC as the onshore court would understand it. So they were saying that the application and the judgment that had been made was to sell the assets or the shareholding of the company, of the debtor in the company. And because it's not an LLC, you cannot do that. So the application was refused. And they actually did say there's another provision of the law for general companies which does allow a sale of shares. So they're saying you can't do it this way. You probably should have done it that way. But the problem is when you look at the bottom of the judgment, it says, therefore, the court appealed to accept and to revoke the appeal decision, the request to sell the appellant's shares. So at some point, the word share and shares is being used interchangeably.
This is the Court of Appeal of the onshore courts, isn't it? Yes.
On an execution decision, they have said, and Jeremy Cook's decision is the only way to understand that is that the application they thought was to sell the share of the company's assets under Article 81, and that had to be dismissed. You can sell the shares of a debtor in a private company, but that wasn't what was going on, so they overturned it. Jeremy Cook says that is the logical explanation of this decision. He says translations may be imperfect, there may be room for debate about it, but ultimately it's irrelevant because this is all a matter of onshore law. It is procedural and it doesn't matter. So there was some confusion. That application was brought in the wrong court, but this decision does not tie the DIFC court. No, it couldn't possibly do so. And I'll tell you why now, because it is clear that execution decisions of the onshore courts are procedural decisions. They don't go to substantive issues and they don't go to jurisdiction at all. And Your Honour, you asked Mr. Patchett-Joyce, is there any authority about this? There is lots of authority. We cited it to the judge and he cited it in his decision.
Okay, what are those? Can you help me?
Yes.
Page,
First
page.
The first decision, I think the main one, is the English court decision of Investbank and Husseini. You'll find that at 3144.
3144.
Yes, and we set it out in our skeleton for the hearing, for the appeals, etc. This judgment is almost identical on the facts here. It was enforcing an Abu Dhabi judgment in the English courts in circumstances where it could not be executed in Abu Dhabi. Not only did the Abu Dhabi courts refuse to execute it, there was a law that said you cannot execute these kinds of decisions. And the English court says, as a matter of common law, that doesn't matter. If the judgment is final, binding, and so on, it can be enforced under English procedural rules, and the procedure of the forum, the host court, is irrelevant as long as the judgment.
Yeah, but Mr. Holloway, shouldn't all these issues be decided at the Court of Appeal instead of just refusing a PTA?
I'll come back to that. But the reason why it shouldn't be decided at the Court of Appeal is because it's clear as day that the answer is exactly the answer that.
No, Mr. Justice Cook followed the judgment, the English judgment.
Well, no,
But,
Your Honour, it's more than the English judgment. I'll take you through that, but you know, it's set out in Sir Jeremy Cook's judgment. But it's not just the English courts, not just the common law courts. It's the same principle onshore. There were two Court of Cassation judgments cited. Sir Jeremy Cook referred to them. I can refer you to them again. For example, the Cassation Court decision, page 3617, Sir Jeremy Cook referred to that. An execution decision is procedural. It is not substantive, and that means it is not binding. And so we've put common law cases in, we've put civil law cases in. It's just a very obvious principle, Your Honour, that execution and enforcement follow the rules of the lex fora. They don't follow the rules of the court where the judgment was made. That just couldn't possibly work. It is just a basic proposition of law, and it's procedural law. It doesn't go to jurisdiction. But even if it did, there would be no question that when you're enforcing an English judgment, you're bound by the execution procedures of the English court. It just couldn't work that way. So there was common law authority, Court of Cassation authority from the UAE, and nothing ever came back from the other side to say that is wrong, because it's a very obviously right point. They've not ever said or cited anything that would suggest that an execution decision in Dubai has effects going beyond Dubai shores to other execution courts. They couldn't possibly do that. There's no argument on that. That's unanswerable. So Jeremy Cook was right on that.
okay. The investment bank case,
Yes.
is cited by Sir Jeremy at page 3144. Is that what you meant just now?
No, I'm giving you the page reference to the.
Or page reference of the case, is it?
But it is referred to in his reasons, and that would be.
But the case itself, I want to read that case. I want to read the investment bank case. Where does it appear in the record? Which can help me, please?
Sorry, I thought I'd give you the page, but let me get it again.
No. What you gave just now was cited by Sir Jeremy at 3144.
No. It's 3144 is the first page.
Is the case where there is filed. Okay. Then it's fine. Okay,
And,
I'll get to that.
If I can probably help you by giving you some paragraph numbers, if
Okay, fine. Can you give me para of the case?
It's really 34 to 36.
34 to 36. Okay.
And that will be at around 3065.
Okay, that's okay.
And then 40 to 62.
Okay.
At
That's fine.
or mine, yes. So that's that. Nothing was ever said to the contrary, either at the hearing or since. So it's a procedural decision. That Court of Appeal decision is procedural. It's to do with execution. It doesn't undermine the enforceability of the original judgment and everything that flows from that. And in reality, Mr. Rashed didn't participate in the hearing, didn't participate in these proceedings. He spent the last year bombarding the DIFC registry and the onshore courts with applications for further letters confirming that Court of Appeal decision. But nothing that flows from that decision has any greater force than the decision itself. It's a procedural matter, and you cannot, it was before the court, the consequences were before the court at the time the order was made, at the time of the return date. We cannot turn around 18 months later and say, I've got a new letter from the Dubai court asking you to give greater effect to the Court of Appeal decision. The Court of Appeal decision has the effect that it has, and the Dubai court, it cannot give it greater effect than it has by writing further letters to a year and a half after this enforcement order was made. I do want to come back now to the more fundamental jurisdiction points, Your Honour.
Yes, please.
So I think you asked a question at the beginning as to whether Mr. Patrick Joyce was suggesting that a Dubai court judgment should, you should be applying here the Dubai court procedures to execute a DIFC judgment on. The answer is quite obviously not, for the same reason that I've just given, but it's clarified in the JAL, but it's also clarified more fundamentally in all the legal instruments underpinning this court, which stress the independence of this court from the other courts, and the fact that Dubai law, Dubai procedural law, Dubai substantive law is not applied unless the parties have chosen it, and of course they've not. There's no question of that here. So I'm not going to go through it, but there's a listening. For example, you have the financial free zones themselves setting up the independent courts and exempting you from onshore procedural laws. We also have the court law, Article 6. The purpose of the law is to provide an independent administration of justice in the DIFC. And then if one looks at Article 42 of the court law, it says orders and awards issued or ratified are enforced within the DIFC in accordance with DIFC rules, and when it's outside the DIFC, the local court governs that procedure. You have exactly the same system in the JAL. There's an allocation of jurisdiction. When you're enforcing and executing in the DIFC, you use DIFC rules, and the DIFC court has jurisdiction. If it's being enforced in Dubai, the Dubai courts have jurisdiction.
No, I want to be. Can you see what Mr. Patrick Joyce did was he went line by line of 7.4 and 7.5.
Yeah.
And is there anything in the Dubai law which will contradict his way of interpretation?
Yes, indeed. It's pretty clear.
Okay, what does the Dubai law say?
I'm going, not Dubai law. I'm going to go through the DIFC law. There's nothing in Dubai law.
No, sorry, no. I beg your pardon. The court law. You were saying just now.
I'm sorry, we're talking about the JAL.
I am talking about the DIFC law, not the Dubai onshore law. I'm talking about the DIFC law. There is another DIFC court law which also sets up the court. Yes. So, is there anything there that goes against the interpretation that Mr. Patrick Joyce?
Everything goes against it.
Okay, can you show it to me, please?
Let's go through it one by one. I mean, Article 7.1 to begin with at page 758.
Yes.
Now that, Mr. Patrick says that's irrelevant, but it's not. It is the provision that gives the execution judge control over the execution process in the DIFC. So when we are doing what we're doing today, which is executing in the DIFC, it allocates expressly jurisdiction to you or to Sir Jeremy Cook or the execution judge. And then Article 7.2, if you look underneath there, draws a clear dividing line. So when the subject matter or is inside the DIC, this court has jurisdiction. When it is outside, it is to be done by the courts outside, and it's inside and outside. Those are the two controlling.
Yes, I mean, logically speaking, that is how I thought.
Yeah,
But Mr. Patrick Joyce went into the
Yeah,
wording, the
I'm
actual wording.
I'm coming to it. I'm coming to it provision by provision, Your Honor.
Yeah. Well, can you tell me what the page is, please? Page of the
seven,
bundle.
seven,
Seven?
five,
7.5?
758, 759.
758. Okay, 758. Let me see what's on 758.
I'm taking you through it provision
Yeah,
by
please
provision.
go ahead. Go ahead, please.
So 7.1 and 7.2 give a clear dividing line as to which courts execute where.
Yes.
7.1 is for execution in the DIFC, and it uses the word jurisdiction. It confirms your jurisdiction to execute within the DIFC. Section 2 clarifies that if there's execution going on anywhere else, then it's the other court's business. So what goes on in Dubai is the Dubai court's business. What goes on here is the DIFC court's business.
Yes.
Then if we look at 7.4, there are extra provisions here about Dubai, and they don't talk about jurisdiction at all. These are procedural provisions. That's what Jeremy Cook decided, because they tell you how to do something rather than what to do.
I understand that.
So the first argument is that 7.4 and 7.5 are specific provisions to do with executing Dubai judgments, but they don't go to the court's jurisdiction. They are telling you what needs, the procedural steps that need to happen for execution and enforcement in Dubai judgment here.
I've got here 7, 5, 6, 7, 7, 7, 1. The execution judge assigned prior pursuant to shall have jurisdiction over execution of judgments, decisions, and orders rendered by the courts and arbitral awards ratified by the courts if the subject matter of execution is situated within the IFC, and such execution shall be in accordance with the rules of the court. That's clear. Where the 7, I want to go to 7.4. Where the subject, this is the sub articles which we've been cited by Mr. Patrick Joyce.
Yeah. So,
where the subject, pardon?
Yes, indeed. Yes. So
where the subject matter of execution is situated in the IFC, let's take the subject matter is the shares. Where the subject matter is situated in the IFC, the judgments, decisions, and orders rendered by Dubai courts. This is the judgment, the order, the judgment given, shall be executed by the execution judge of the courts The courts there must be the which courts? The DIFC courts.
Yes, it's our court, it's the court,
Be
yes.
executed by the execution judge of the courts, which is the Dubai courts. Sorry, the IFC courts, subject to the following conditions.
Yeah.
The judgment, decision, or order to be executed is final and executory. That is clear. It's final. It's gone up to the highest court in
Yes.
Dubai. On land, on shore, it's gone up to the judgment, decision, or order is translated English. I assume it's all done. Dubai courts affix the executory formula on the judgment, decision, order.
Yes, it was done.
Now, the question in C.
No,
The
no,
executory formula.
no, that there's no dispute about any of that. That 7.4 has been satisfied. It's 7.5 that the dispute is about.
Okay. In addition to paragraph A, B, C of clause 4 of this article, when executing through the courts, the judgments, decisions, or orders issued by Dubai courts, the following shall be observed. A. The Dubai court shall issue an execution letter to the Chief Justice of the courts stating the procedure to be carried out. To the person, why does it tell us? Why should the be telling us how to carry out the procedure?
Well, indeed, there's what does that actually mean? What it means, what Jeremy Cook said it meant, is that it identifies the judgment and the executory bit of it. So if it's a judgment that says he must pay $1 million, it tells you executed in that way. What it doesn't do is tell you Dubai procedures for executing. It cannot do that. That would be a recipe for absolute disaster.
Makes sense.
And the other thing that it doesn't do is tell you which assets can be executed against and which cannot. That's not
Dubai
what
court shall issue an execution letter to the Chief Justice of the court stating the procedure to be carried out. The procedure to be carried out. The person requesting execution shall submit to the execution of judge an application accompanied by a copy of the judgment, decision, order, legal transition, and the execution letter. The execution judge of the court shall apply the execution procedure and rules stipulated in the rules of the court, including any objections to execution, any objections to execution. The execution judge may not reconsider the merits of judgment, decision, of order. The court shall collect the execution fees for each execution request submitted to them. And 6, the judgment decision rendered outside the DIFC court by any other court in the record shall be executed within the DIFC in accordance with procedure prescribed in the rules of the court. So what's the difference between 6 for courts outside Dubai courts and Dubai courts?
The difference is procedural steps that need to be taken. That is all. So the letter that is needed, the stamp, etc. That is it. These are procedural steps. They're not jurisdictional requirements at all. And that's what Jeremy Cook found. They tell a court how to do things. They don't tell the court what it has jurisdiction to do or what it doesn't. The operative provision is 7.1, which gives.
But Mr. Holiday, wouldn't you agree with me that if, I'm just saying, if Mr. Patrick Joyce is right in saying that the procedure to be followed is as set out by the Dubai courts, right? Then the IFC must comply with it if he says what he says is correct. The Dubai court sets out the procedure and the IFC courts will comply with it. That's why he says.
Well, that couldn't possibly be right.
Yeah, I know you say it's right. Doesn't matter.
No, it just.
But whether it's procedural or whether it's substantive, the fact remains you have to follow the law. Doesn't matter if it's procedural. Does not mean that if it is procedural, I don't have to follow the law. You still got to comply with the law.
What it means is Mr. Rashed is only permitted to challenge the decision of Jeremy Cook if some fundamental, obvious mistake relating to the court's prima facie jurisdiction is
that what the law of PTA is about? I don't think so. 44.19 and all those 44. I don't think that you are restricted to that.
No, it's not.
So.
No, it's not restricted in
because if Mr. Patrick Joyce's arguments is correct, and let's assume he's correct, then the DIFC courts will have to follow what the Dubai courts says, and then that's opening a new issues altogether. Well,
you know, it's not that.
I'm not saying he's right. I'm not saying he's right at all. I'm just.
It's
one
not
of the things that's going into my mind now.
If I could answer, it's not that 44.19 in any way limits what Mr. Patrick Joyce can argue about. Well, the limit to that is found in the committal order, which was not appealed, which suggested that Mr. Rashed may only raise arguments in these proceedings, only raise arguments that go to the court's prima facie jurisdiction to make the orders that it did.
Now you are saying that because of the order that is still not purged, is not allowed to go into procedural but merely into the substantive law. That's what you are saying. Because he has not purged his contempt.
No, it's not procedural and substantive. It is basically and it's not to do with, anything other than the committal order restricted Mr. Rashed from raising any arguments which were not related to the court's prima facie jurisdiction.
Now, he can challenge only if it affects prima facie. He can, D1 can challenge only if he is challenging the prima facie jurisdiction of the IFC courts.
Yes.
Which means 7.4 and 7.5, right?
No.
No.
So my first submission is that 7.4 and 7.5 do not go to the prima facie jurisdiction, and that's what Sir Jeremy Cook held.
7.4 do not go to prima facie jurisdiction. So prima facie jurisdiction is the first seven.
No, let me explain.
No, not 7, 5.
So Article 5. Let's go back to
Article 5. You are saying that you can only argue on Article 5, interpretation of Article 5.
So the only argument that he's permitted to run, and it's been rejected by the judge already, is that this court did not have any jurisdiction to recognise, enforce and execute the Dubai judgment. And I'm now going to tell you why it's obvious that the court did have prima facie jurisdiction, and it's unarguable. May I proceed?
Yeah, sure. Please do.
The first thing I want to take you to is the Article 5 1A.
Yeah, 5 1A.
Just up the page.
Yeah. Civil or commercial claim. The first instance shall have exclusive to hear civil commercial claims which is a part.
5A 1E. So that's at 758 at the bottom.
Yeah.
So this is the jurisdictional provision. It's not Article 7, it's Article 5.
Any claim or action over which the courts have jurisdiction in accordance with the DIFC laws and the IFC regulations.
Now, I'm going to take you to the laws and regulations which clearly give jurisdiction in this case, if I may, just one at a time.
Please.
And we're talking here about DIFC laws and DIFC regulations. So the first one I want to turn to is the Rules of Court 45.8, which is at page 790.
87
790.
790. Okay, sorry.
And then, sorry, just down the page, it's at 791, 45.8.
The first time I'm going to so deeply on the question of PTA. I've dealt with so many PTAs, not so difficult as this.
Well, it's actually not difficult, but there are many reasons why it should not be granted.
I'm at page 790.
791 at the bottom of that page. These are part 45 is the part which allows enforcement of judgments and orders. It is a DIFC law, it is a DIFC regulation, and it says that a decision of any court, tribunal or body other than the court can be enforced by this court. So that rule gives the court jurisdiction, provided that an enactment provides that an award may be enforced as if payable under a court order, etc., etc.
Wait, sorry, I beg your pardon. Where were you reading? 445?
45.8.
0.8. Okay. If rules 45.10 apply if an award or some other than the court.
So that's any foreign court, including the Now the question then is there an enactment that provides that an award or judgment can be enforced that way? And the answer is yes. First, there is the court law, Article 24. 772.
Yeah.
24, sorry, 24.1, and then it talks about ratification, and that's exactly the enforcement order that we got was a ratification order. It received the Dubai court judgment into the DIFC for recognition and enforcement. This is the enactment that allows us to do that. And you'll see that it refers to all non-DIFC judgments and awards, including those of the Dubai courts, specifically those of the Dubai courts. Now, Mr. Patchett-Joyce's argument is that that only gives jurisdiction if the Dubai courts say that it does, and he says it only gives jurisdiction if you're executing against assets that are permitted by the Dubai courts. And I'm sorry, Your Honour, but that same argument has been comprehensively rejected by this court many years ago in the DNB Bank case. That's exactly what the people in the DNB Bank case were saying. And if I can just, I think the passage to read is paragraph 97.
97 at page?
DNB Bank case. Let me find it. It should be. Yes, it should be at page 3136.
Okay. What I know that was cited by Justice Cook in his judgment, but he just sort of mentioned like that, cited without without going into the, can you remind me what the cases are about? I've read
Well,
it, but
it was the enforcing an English judgment, and they were using the DIFC courts to recognise it and then refer it to the Dubai courts for execution in Dubai. And the judgment debtor said, well, you can't do that because this jurisdiction doesn't apply. You can't ratify a judgment. You have to only ratify it if you're executing it. But in terms of jurisdiction, the nub of it is paragraphs 96 and 97. This is why the court plainly has prima facie jurisdiction. And
so what you're saying was in DNB bank case, the English bank asked the DIFC courts to enforce, to ratify that judgment, and then enforce it in Dubai courts. Is that what happened onshore Dubai?
Yeah.
Goes in here and goes back that other side.
yes, that's right. And they argued was there's no jurisdiction to do that, that you cannot ratify unless you're executing. But it transcends the fact of that case. Paragraph 97 basically says, I'll just read the bit that I think puts this case to bed, is that what I just showed you, the third line of that, the reference to the RDC is provided by 45.8, which requires that the order from courts other than the DIFC courts can only be enforced directly if an order requires payment of a sum of money and an enactment provides that the decision may be enforced as if payable as an order of the DIFC court. Clearly, Articles 74276 of the JAL and 24.1a of the DIFC court law are enactments that provide for foreign court decisions to be enforced within the DIFC. Accordingly, I find that 45.8 is satisfied by virtue of 24 of the court's law read with 7.4, 5 and 6 of the DIFC court law. The court has jurisdiction to hear claims for the recognition and enforcement of foreign judgments. And if I can go back to paragraph 96 above, talks about the amendment. I agree that the reference to 7.4 was the reference to 7.4, 5 and 6 as amended, referred to the enforcement within the DIFC of judgments and awards of any court outside, provide for the enforcement of the DIFC of judgments, decisions and orders and ratified, rendered by Dubai courts or any other court than the DIFC court. So the jurisdictional gateway is 5.1a, 5a, 1e, read together with Article 24 of the court law, which specifically refers to Dubai judgments, and DNB Bank case, which adds 7.4, 5 and 6 of the JAL. Those three provisions and DNB Bank mean that Mr. Patrick Joyce's case is just unarguable. You cannot say that a Dubai judgment, that this court does not have jurisdiction to ratify and enforce a Dubai judgment. And then I'm just going to, I'll cut this slightly short. If I could take you back to 45, Rule 48 again.
Wait. Let me note this down before I forget.
Yes.
Page 772 is Dubai. I said court law. Court law, para 24. Para 24E. Quarter 24E, and the other one is Article 7.4 and 7.5. Okay, now you were referring to 44, did you say?
All right, back to the rules 45, part 45 again. And I think that's at 790. It's abundantly clear in all of these rules, but look at 45.2. Can you blow it up?
790. Wait a minute.
Yes, 790, and then Article 2, 45.2.
71945-2, okay.
Yes.
Okay.
So I'll just tell you what I'm getting from this, but you can then have a read. But remember, this is the part that talks about orders and how to enforce them. And it says, if you look at the definitions, a judgment or order includes an award which the court has ratified for enforcement, etc. And then going down to 45.3, methods of enforcement. So you're in DNB Bank, Article 24 of the court law, you ratify a Dubai judgment, and after that, all of these enforcement remedies are open to you: charging orders, execution of assets, and appointment of receiver. Dubai law is just inapplicable. So you look at, and sorry, just one final reference, if it's not clear enough, is the court law echoes that later. If I can get my page references right.
Court law is what page?
If you look at 779,
Yes.
Article 42,
Yes.
it really just repeats what we're saying. This is the DIFC law. Judgments, orders, or awards issued or ratified by the DIFC courts may be enforced within the DIFC in the same manner under the rules of court. So in terms of jurisdiction, 5A1E, 24 of the court law, 42 of the court law, Rule 45 of the rules, and paragraph 97 of the DNB Bank case make it absolutely crystal clear and unarguable that this court has jurisdiction to ratify and enforce a Dubai judgment. The enforcement order is unimpeachable. It cannot be challenged. My learned friend in his skeleton argument says there's no need to ratify a Dubai judgment. And I think he goes even further to say it's inappropriate to do so. That's not the point. The point is whether the court has jurisdiction to do so. And Article 24(1)(a) of the court law specifically says the court has jurisdiction to ratify a Dubai judgment. So it's.
But in this particular case, the Dubai judgment was ratified, recorded as ratified.
Yes.
Huh? Yeah.
The first order that we got
was ratified. I mean, I can't remember.
Yes, it was an enforcement order.
Dubai judgment was ratified.
And only after that the other orders were possible, because the judgment needs to be received. Now, Mr. Panchajoy says, well, you can just execute these things directly, and you have to follow the Dubai court's permission. That's just not what the law says. It's unarguable.
The reason why I asked that, I thought, reading it just now, that the ratification applies only to arbitration.
Well,
no,
that doesn't come across from Article 42 of the court law, and it also doesn't come across from 24 of the court law, which specifically says that the court has jurisdiction to ratify any judgment of the Dubai courts. So Article 24 makes it plain as day that the court has jurisdiction. And what Mr. Panchajoy is saying is that you've got to follow the Dubai court's rules and procedures. Well, that's not a jurisdictional question, because the other statute give you jurisdiction to do it. His complaint is a procedure.
Para 24 did speak about ratification. Sorry, is it section? What do you call it? Section, para, or article?
I don't know, actually.
I think it's section 24 of the Dubai law. Not Dubai law, of the court law. 24 of the court law.
And then just a final point on this. When these orders were made, there was an execution letter. It said you can execute against all the assets of Mr. Rashed. It's a year later that another letter has come back, Now, if this is the final process of enforcement, it just can't be right that we judge it based on the latest version of what the Dubai execution judge says, because a judgment would be enforceable and not enforceable from one day to the next. If it's enforceable in February and he doesn't show up at the return date in March, and then a year later he says, well, I've got this other letter, it can't possibly work.
That is why the DIFC courts was established by the ruler.
Exactly. This attempt to use obscurities in the onshore proceedings to derail what should be the most straightforward of applications. My Lord, Your Honour, no. Now, I don't know what to turn to next. We've done the decision on execution.
I think the case of Mr. Patrick Joyce and yours is how I give interpretation to 74, 75 and the 24. That's it. If I'm satisfied that there's no chance of success, no likelihood of real prospect of succeeding, because your interpretation and Mr. Justice Cook's interpretation of 74 and 774, 75 and all that they read are correct, then it will be dismissed.
Well,
but if I consider Mr. Patrick Joyce's submission and say that if the Court of Appeal accepts his submission, then there is a potential likelihood of real prospect of success, then the application will be allowed. Basically, that's how it's my mind now. What's running in my head now?
There are two limbs to it. Can he show you to a real prospect of success that 7(5)(c) is a jurisdictional provision rather than a procedural one? Can he satisfy that it overrules all those express laws giving you jurisdiction to enforce and execute? Answer, obviously not. Even if he could he satisfy you that it means that the Dubai procedure is the one that we have to follow in the DIFC? Obviously not. So in my submission, it's a dead end, whichever way.
But Mr. Holloway, let's assume that the case go for appeal, hearing and appeal, and then you still succeed the appeal. Is there any real damage between now and the time the appeal is heard to your client, except that they don't have access to the fund immediately?
Well, then let me just, I'll make quite a few submissions on that. I think the starting point is this judgment was given in 2016.
Pardon?
In 2016.
Yes, I noticed that. I noticed that. This thing since 2016.
Yes.
Yes, I realized that. But my duty today is to interpret that 44.19 and apply the 44.19.
Yes.
That's why, although Mr. Rashed has lost a lot of sympathies with the judges, with the courts, the way he has been acting.
Let me make the submission, Your Honour, and then I'll close.
Yes.
But I have a number of points to make on this.
Yes, please.
I think they need to be said. It's a 2016 judgment. He didn't appear at the return date. He has refused to comply with orders of the court. He has hidden his assets. He's still hiding his assets. The judgment is undisputed, number one. Number two, with the very greatest of respect to Your Honour, we really should not be here today at this hearing arguing this. And we shouldn't be here because Mr. Rashed had a chance to have an oral hearing on the 28th of May. Now, that hearing was listed. I prepared for it. My law firm prepared for it. Sir Jeremy Cook prepared for it. And what happened? It didn't go ahead. And why didn't it go ahead? Because Mr. Rashed didn't participate in the hearing. He stopped paying his lawyers as far as Jeremy Cook was concerned, and then just thought, well, I'll delay things a bit longer. That whole day was wasted. The costs were wasted. It's one of a series of costs orders that has never been paid, and we are put to the trouble of going through this bundle again and again and again. Now, in other words, everybody's time was wasted on that. He's a persistent and flagrant contender. It's probably, we'll see bombarding the onshore court with applications which are solely designed to disrupt these proceedings, bombarding the registry with correspondence, telling them how to reply to the Dubai court, etc. We shouldn't be here at all. The arguments are all spurious. These are debt dodging arguments, playing with words. Sir Jeremy Cook came to the conclusion that the end of the line has been reached and we shouldn't have had another oral hearing today. He's had the chance to have an oral hearing today, and I think the court should send a strong message, now that we're here, that this kind of behaviour just is intolerable. And just one final point. Mr. Patrick Joyce, too polite to do it, but they've made some very serious allegations of bias against Sir Jeremy Cook in a letter, which is, petty complaints about they didn't adjourn the hearing. Fine, he didn't ask for an adjournment. But if you look at, there's a letter that was written by Mr. Rashed's legal representative to the registry on the 10th of, it's on the 10th of July. Most of it deals with stuff that's not relevant today, but there are two allegations in there that Sir Jeremy Cook decided things against him because he was biased. Now that doesn't appear in the skeleton argument. That letter should never have been written by a man and his lawyers who are serially flouting and disobeying decisions of the court and refusing to honour a judgment that it's unacceptable. So if you are minded by any way to let this be argued further for more time, there have to be serious conditions imposed on any ability to take the appeal further, and it goes beyond the contempt now. The Jeremy Cook fines have been levied for contempt; they haven't been paid. Costs orders haven't been paid, and the judgment debt, Jeremy Cook has ordered that to be satisfied. It hasn't been satisfied. Proper security has to be given. The cost orders have to be paid. The judgment debt security that has to be paid in. He talks about lack of assets in the DIFC. We don't know where the assets are because he's in breach of the court orders to disclose his assets. Probably you don't need to read much to read into this, but the appeal should be squashed. This should be the end of the line. If not, litigation isn't a sort of each way bet where you get to put the other side and the court to great trouble on the basis that you might win in the end. If cost orders are made, they have to be met. If fines for contempt are levied, they have to be paid. All that needs to be done. So, and then.
So, if you sell the shares now, is there enough to cover your claims, your costs, your penalty, everything?
The answer is we have absolutely no idea because the murky affairs of this man and his entourage are being unravelled very slowly and reluctantly. So they will tell you, oh, you've got the shares. We have no idea what the true position is because he won't let us have that. But
maybe the contempt should go to jail, go to be incarcerated.
Final point.
Anyway, that's not for me to say.
There's one more point. It's the final threshold point. I'm not going to talk about it. But even if you went through all that, there's no basis for this application at all. He didn't appeal the original orders. All the information was before the court at the time. He didn't apply for 7. I've developed this in the skeleton in detail. I'm not going to deal with it now, but there isn't actually any legal basis for Jeremy Cook's orders to be set aside or appealed. They certainly didn't appeal them. And you can't turn up 7 months later and say the Dubai Court of Appeal has said that was before the court at the time. So that's another threshold point to say that all this stuff, it's not jurisdictional, it's procedural. But even if you got over that, there's a brick wall that he just can't get past. And if you get past all that, he's got to pay the money in and pay the cost orders. We shouldn't be tolerating this behaviour anymore. That's all I have to say. And thank you for your patience.
Thank you very much, Mr. Holloway. Mr. Patchett, can Patchett Joyce, can you just make your closing speech brief? You want to say?
Yes, I shall. Your Lordship will forgive me if I don't go into detail of correspondence.
No,
I am going to stick to law and facts.
Yes.
So far as this matter going further, Justice Jeremy Cook expressly contemplated that it would go further or might go further, and that was the reasons why he set out his reasons in the 30th of May, which is beginning at page 4731, and he sets out his reasons for refusing the permission to appeal on the argument before him at 4735. And it was expressly on the basis that lest the matter go further, and it has. So that deals with those 2 points. Let me go back. My learned friend seeks to introduce obscurity. There is absolutely no obscurity in the judicial authority law. If one begins at page 758, if Your Honour can turn up 758.
Yes.
Learned friend relies on paragraph 1. The execution judge assigned shall have jurisdiction over execution of the judgments, decisions and orders rendered by the courts and the arbitral awards ratified by the courts. What is meant by the courts? The courts is a term defined in Article 2 back at 756. So this is talking exclusively about judgments, decisions and orders rendered by the DIFC courts.
Yes.
We are here dealing with a judgment of the Dubai courts and its execution. Article 7.1 is nothing in point. The obscurity and the confusion is, with respect to my learned friend, being introduced by the claimant, because he is introducing in his argument an utter irrelevance. If one goes on page 759, Article 7.4, as I submitted previously, has important qualifying words where the subject matter of execution is situated in the DIFC courts. That plainly is referring to what I've termed executable assets and is plainly leaving to one side non-executable assets. Learned friend has not addressed that clear, important delineation at all. And
yeah, I said that the shares are in the DIFC courts, but
Yeah.
you are now arguing that it doesn't include the shares because the court in Dubai said don't include the shares.
Absolutely. And that is precisely the effect of Article 7.5, and Articles 7.4 and 7.5 are in contradistinction to Article 7.6, which deals with judgments, etc., outside the DIFC court by any court other than the Dubai courts. It's very clear when you read it. There is no obscurity, but you must read the totality of the judicial authority law to understand what it is actually saying. My learned friend then said,
but Mr. Patchett Joyce, if you read all the cases relating to jurisdiction, JAL, the court has not limited the interpretation to the words used in JAL only. It has referred to the courts, the what they call the court law, the court law, which you have just referred 24.
And
They
Your Honor,
look at all the laws and gave that interpretation. It is not read within JAL only. You read so many cases. I mean, I've given 1 or 2 judgments
yes,
where I
I'll come
cover all the legislations. So you cannot read JAL by itself. You have to read JAL in the context of the court law and then the RDC as well to arrive at what JAL meant or means.
Yep. Your Honour is absolutely correct, and I will deal with all of the 4 limbs that my learned friend relies upon. They are baseless, but I'll come on to that in a moment. The learned friend said what the JAL doesn't tell us is which assets can be executed against and which not. That is precisely the purpose of the execution letter and correspondence. And as you've seen from the table that I took you to, it couldn't be clearer. You yourself, Chief Justice, put to my learned friend that the DIFC courts must follow Dubai court execution procedure. And that's correct. But when the boot is on the other foot or the table's turned, exactly the same thing applies. The Dubai courts must and do follow the DIFC court's execution procedure. And this is made absolutely clear in the DIFC court's own enforcement guide, which is at begins at page 1172. I won't turn it up for reasons of time, but it's there. And also in the protocol. That's the whole reason for the protocol between the DIFC courts and the Dubai courts. And you'll find the summary of the protocol beginning at page 1181 of the bundle. My learned friend was asked, or you asked my learned friend, about execution directly as between the Dubai courts and the DIFC courts. That again is precisely the purpose of the enforcement guide and of the protocol between the 2 courts. My learned friend sought to rely on Article 5 of the JAL, which is headed jurisdiction. But when you read it, what that is plainly doing is allocating jurisdiction between the courts of the DIFC, nothing more. It doesn't relate to jurisdiction in relation to execution, which is dealt with in Article 7. The question of ratification I have discussed. I won't spend time, but for your Honour's reference, I discussed the curiosity of talking about ratification in paragraph 48 of the claimant of the first defendant's skeleton argument in support of this renewed application. It is to be found at pages 4768 to 4769 of the bundle. And the point there basically is ratification is an odd concept in the context of judgments, because it usually only applies either to international treaties or if you are ratifying the act of, say, a company agent ex post facto, so that it becomes intra vires the company. But that's discussed, as I say, paragraph 48 of the submissions, pages 4768 to 4769. Let me turn to the 4 bases on which my learned friend relies. And the straightforward point here, Your Honour, is he's wrong on every count. I suppose if one's going to put it slightly more politely, he's clutching at straws, but he doesn't grasp any of them. The reason why he doesn't grasp any of them, or the reasons why he doesn't grasp any of them, are as follows. The first point is he takes the court to the rules of the DIFC courts, but that overlooks the primary requirement in Article 7(5)(c) of applying the execution procedure. Only thereafter do you turn to the rules if there's a gap, but here there isn't a gap. So his first submission overlooks the very wording of Article 7(5)(c). His second point is Article 24 of the Courts Law. But Your Honour has seen Article 24 of the Courts Law. It is the introductory wording of that article is as follows: pursuant to Article 7(4) of the Judicial Authority Law. Now, that needs to be updated because of the amendments to the judicial authority law, and it should read pursuant to Articles 7.4 to 7.6 of the judicial authority law. But it is absolutely plain that the court law is subordinate to the judicial authority law, as one would expect that a DIFC law keying off an Emirati law, so the court law being a DIFC law, keying off the JAL, which is a Dubai law, the DIFC law is properly respectful and subordinate to, expressly so, to the Dubai law. So his second point leads nowhere because it runs into a brick wall with the opening words of Article 24. The third point that my learned friend relies upon is the DNB Bank case. We have dealt with that in paragraph 58 of our submissions, which is at page 4772. Reference to and reliance on DNB Bank is nothing to the point. The DNB Bank case concerns a foreign, non-Dubai court's judgment. The analysis in that case, therefore, is concerned with procedure prescribed in the RDC. The DIFC Court of Appeal has made plain that different considerations as to recognition and enforcement apply to a foreign judgment. The learned friend took the court to paragraph 96, which is on page, he said 3136, it's actually page 3236 in the bundle. And if you turn up the paragraphs that my learned friend relies upon, it is expressly with regard to a foreign judgment. And that is therefore within Article 7.6 of the JAL. It is not within Article 7.4 and 7.5 of the JAL.
Yeah, hang on. Yeah.
His reference is correct. I think your bundle may be outdated. It's 3.1.
Never mind. It's 3236. I got it. 3236.
Okay. Well,
okay. Doesn't matter about that.
Well,
okay.
The bundling has left a bit to be desired, but on the version that I'm working off, it's either 3136 or 3236. The version that I was provided by my learned friend's instructing solicitor has it at 3236. But we don't need to worry about it, because all we need to do is find the DNB Bank case. It's there. Look at paragraph 96 and see that it's expressly in relation to a foreign judgment. And this is one of the fundamental flaws that the claimant makes. GTC Trading, equates a judgment of the Dubai court with a foreign judgment, and it is not. So that deals with the third point, because DNB Bank is relating to foreign judgments. The fourth point that my learned friend relies upon is Article 42 of the court law. Look at the heading of Article 42, and it is headed Enforcement of DIFC Court Orders. We're talking about enforcement of a Dubai court judgment. Article 42 doesn't talk to this point. And in any event, following on from the answer to Article 24 of the court law, the DIFC court law must yield to any contrary provision of Dubai law, and therefore must yield to Articles 7.4 and 7.5. Let me just see if there are further points that I should deal with. Yes. My learned friend says he makes much of the fact that Mr. Rashed didn't appear on the return date. The return date was the 16th of March 2023. Mr. Rashed had been put in jail during that time, and that was why his ability to respond was strictly limited. The learned friend also said that he had spent much time generating correspondence with the Dubai courts. The boot, in fact, is on the other foot. the claimant has persistently been applying to the Dubai courts to the point where it can really be described as pestering the Dubai courts to get a judgment in its favour. The most recent attempt, and it's in the bundle at page 6335, and it may be just a help to look up 6335. Your Honour will see that is appeal number 99 of 2024. The appellant was GTC Trading. The date of the decision is the 21st of August, so very recent. Rendered the following judgment after reviewing the papers, hearing the oral argument and legal deliberation, and then you can go through, in fact, it's a long judgment, but it goes and concludes on page 6340. For these reasons, the court ruled in the presence of the parties that the present appeal may not be considered due to the previous ruling in its appeals, plural, number 2570, and that the appellant is obligated to pay the expenses and an amount of 1,000 dirham for attorney's fees. So the persistence is actually on the part of the claimant.
Wait a minute. What is this? What is this? This is taken by was it commenced by, what is this? Who are the parties to this?
The parties are the parties before the court, before this court. If you go back,
before this judge.
Yes, if you go back
by Judge Appellate, it's GTC.
Yes, could you go back to
GTC
6335?
Seeking for some, and then you are saying that GTC failed. Is that what you're saying?
Absolutely. Your Honour, if you go back to 6335, I went too quickly and for the sake of time.
And the appellant is obligated to be. Okay.
Appellant is identified there as GTC Trading. The respondent is identified as Mr. Rashed. The substance of the attempted appeal is set out in the ensuing pages, and it's an attempt to circumvent the previous judgment of the Dubai courts saying that execution cannot be levied against D1's shares in D2. So, let
me read this.
Yes.
Accordingly, the two judgments issued in the two previous appeals have acquired the force of res judicata regarding the inadmissibility of ceding the shares of the parties against whom the execution is being carried out, owned by him in the company HMR, which holds what is it? I don't understand this. Can you tell me what this is all about, Mr. Michael?
Yes, Your Honor.
Tell me what this is about very briefly. I'll read it later, but just tell me what is this case? Why was it filed? When was it filed? Why was it filed?
Well, I can't tell you when it was filed, Your Honour, but I can
doesn't matter. It's filed in 2024.
tell you when it was determined. It was determined on the 21st of August.
No, it doesn't matter. What is this about?
This is an attempt by GTC Trading to go behind the clear rulings, consistent rulings by the Dubai court saying that GTC Trading cannot execute against D1's shareholding in D2. That is, it was an attempt to, it was a yet further attempt by GTC to circumvent what they have been told consistently by the Dubai court. And unsurprisingly, doing the same thing and expecting a different result, the outcome of that is total disappointment. They got nowhere. Their appeal was dismissed, or their application was dismissed. This is yet another step, and indeed what it says, as Your Honour has just read, it affects res judicata. It has res judicata effect. It is absolutely clear that the Dubai courts have said time and time again, and most recently in appeal number 99 on the 21st of August, literally less than 3 weeks ago, that you cannot enforce against the shares that D1 holds in D2. And that is a substantive judgment with the effect of res judicata, which Your Honour has just identified. It could not be clearer. And that is the position. Now, my learned friend suggests, or he doesn't suggest, it is part of his case that our argument relating to Articles 7.4 and 7.5 is somehow procedural and not substantive. It plainly goes to jurisdiction, because if the assets are non-executable, as the Dubai courts have said time and time again, then the DIFC court has no jurisdiction to execute against non-executable assets. That's what the JAL says, that's what the protocol says, that's how the law applies, and it also is consistent with Sandra Holdings. So that is, that's how it is. You simply cannot execute against non-executable assets. Full stop. Learned friend.
Okay, I think
Well,
anything more?
The only point the only final point is to deal with the Invest Bank case. Learned friend, in the course of his argument, I think said that Sir Jeremy had referred to and relied on that case. It may be my oversight, but I haven't found the page reference where he did that. But my learned friend can doubtless provide that in due course. If he did, so be it. But I can deal with the point in any event. The Invest Bank case, judgment starting at page 3144 of the bundle, that is a case of enforcing a UAE judgment in England. So it is the enforcement of a foreign judgment. It's back to the age-old point which my learned friend overlooks. We are not talking about a foreign judgment here. We're talking about a judgment of the Dubai courts. And if one looks at the way in which, let me just see if I can find it quickly. My apologies. I think there's, let me just see if I can find the page quickly. I'm looking for, well, perhaps I can do it by reference to, sorry, I'd taken it out of my bundle. 4080, my learned friend deals with the Invest Bank case in his submissions, paragraph 32 of his written submissions for the 1st of February, dated the 1st of February for the hearing back in February. And he sets out there, paragraphs 15 and 37. There are 2 points. First of all, it's a foreign judgment. Secondly, it is a first instance decision from the courts of England and Wales. First instance decisions can only in any event be of persuasive authority, and the courts of England and Wales do not bind the DIFC courts. So it is doubly not binding on the DIFC courts. Insofar as it provides any support for my learned friend submissions, in our submission it is wrong, but in fact it doesn't, because all it does is talk about a foreign judgment, which this isn't. So, Your Honour, unless I can assist you further, in my submission I've dealt with each and every point raised by my learned friend, and each and every point is either insubstantial or baseless, and I do ask for permission to appeal.
Okay, thank you very much. Mr. Holloway. I've not
Yes.
made up my mind. It's very, my mind keeps on going like that. And yes, no, which is normal for a judge sitting in any case to say yes, no. But if I am minded to give the permission to appeal, what about you submit, in your submission you mentioned about depositing certain amounts to the court.
Yes, I've set that out in detail in a skeleton argument.
Okay, so you stand by it. You stand by it.
Yes. Yes, absolutely.
I don't have. You don't have to do. I'll read it later. I read through very sketchily. I didn't go into detail, but that's what you're asking for. And of course, Mr. Patchett Choi said that's not fair because your client's position has not been finally determined yet. It's not right for you to get normal requirement, normal submission. Yeah, gosh.
Your Honour, in essence, you're absolutely right. In essence, it's giving the claimant what he wants when he shouldn't get it, because the appeal should substantively succeed. But I'd also ask the court to bear in mind that my client is subject to a freezing order. And what is frozen is a very substantial number of properties. And the value of those properties has been valued at a sum in excess of the value of the judgment debt. So the court should bear that in mind. And also, I would invite the court to bear in mind that any permission of a sale of shares is an irreversible step. It cannot be undone. And on the basis that there is good arguability, and I say more than good arguability, in the case that we wish to pursue, then it would plainly be unfair, grotesquely unfair, for us to be able to prosecute an appeal to success and find that the shares have been sold or otherwise realized. So
how can your client has not provided or rather declared all the assets that he has in the IFC? So how could I know the freezing order is there, but what are the assets that has been frozen?
Well, he owns shares in before his shares in the second defendant company were transferred by court order to receivers appointed and acting on behalf of the claimant. The first defendant was the 100% shareholder of D2. And D2, as you've heard, has assets, and those assets are substantial property holdings, all in onshore Dubai. And those assets have been valued by a court-appointed expert.
Oh, I see. And so your client holds shares in the company, and the company is the one who has a lot of assets.
Yes, and that's all been declared to the Dubai court. Well, and the Dubai courts have valued that portfolio of properties, and the value exceeds the judgment debt.
Okay. Yeah, Mr. Holloway?
I just have to repeat what I said. We were able to freeze the only assets that we could find, which were the shares and the properties owned by that company, after Mr. Rashed had dissipated those properties into the company to avoid paying the judgment debt. Since that, he has not disclosed his assets, and the financial affairs of that company, of which he was the shareholder, are completely opaque. What we've found is that a number of associates and associate companies have passed money, including the rental income, and hidden it. So we know the value of the properties. We have absolutely no oversight as to what's been going on in terms of the general asset picture of either D1 or D2, and that's because they have basically hidden the information. Now that's to be borne in mind. One can't just assume that because we managed to find properties that we're going to, that those are the only assets of the company, or the company doesn't have liabilities.
It's a very long hearing considering it's only a permission to appeal. But I must apologize for taking your time too, because I was seeking a lot of clarifications, notwithstanding I've read through the record, but there's still a lot of things that I need to clarify to hear from you what your views. So give me a few days to think it over, to read again all the documents that I have to reread again, reconsider again, and then I'll come up with you with a judgment. So anyway, for now, thank you very much, Mr. Patrick Joyce and Mr. Holloway. Thank you very much for.
I'm very grateful to Your Honour for the time given to us to fully expand the arguments.
Okay.
Thank you both.
So thank you very much, Mr. Holloway.
Thank you.
Yeah.
Oh,